Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
The wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addicts live stream in their court.
The fireworks are not done.
Or doing commentary on the case.
That's correct.
Not him, he's Anglican for he's verbal talking. That's literally not true. I didn't ask you to interrupt me. Oh, for brother's sake.
Alrighty. I think it's working. I think it's working. Can you guys hear the music? Can you hear me? Welcome to the Court of Public Opinion. I am the Recovery Addicts. Thank you very much for joining me. I've had a little bit of a rest. I'm not sure if I'm ready for this. I really am not sure if we're ready to go on. We did a little bit of reading this morning. A little bit of light reading. It does sound a tiny bit funny. We'll turn the music down a tiny bit. Close down a few windows, see if that helps a little bit. All right, we are back. It does sound a little funny. I'm running through StreamYard. It changes the audio just a teensy bit. Let me know if it's a problem. Actually, as a matter of fact, let me change something really quickly and see if this helps. Audio is off. Oh, I'm so excited for this. I'm so excited. I see you there. Don't go anywhere. Let's see. Audio. Let's go in from real. Boom. There we go. And that way I will hear her here. Hear who, you say? Hear who? Let's see, let me go to this and this and this and then this. That's this. Welsh Lady Reads. Can you
Hello, Scott. How are you?
I'm doing well. How about yourself?
I'm good, thank you. Thank you for having me.
I am not sure if you're as excited as I am about you reading some of this document. We're not going to finish by first of all, it's going to be very, very dark in your part of the world before we're done with this. It might be a 3-day live stream just to catch up. We'll see how far we can get into it. But what have you thought so far? For those that don't know, this is Welsh Lady Reads. Let me put your logo on the screen here.
They set up a scene, you know?
There we go. Now we've got you pulled up. We have a professional reader with a wonderful Welsh accent, and who better to read the transcript of a Georgia court than Welsh Lady Reads,
who has followed it from day one.
Yes,
seen every day.
There you go. Every bit of it. It knows it like the back of her hand. This is going to be just wonderful. I love it.
Well, it's fun and exciting, and it is Scott.
We have our document. Are you able to see from this view?
I am. Yes, I am.
If I just ran this like a teleprompter, does that work for you?
I've got it. I've been biggened it. My end.
Oh,
so
good.
I'm fine this way. I still get to see the chat, but I got my phone for chat if there's anything in there, you know. But I'm going to be reading, so I don't see chat.
I don't see chat either. I'm not even sure if anybody's there, honestly.
I think there might be one or two.
Right.
Don't forget to hit the like button.
It's just us between friends. We're just going to read this together then.
Yeah.
Let's see how far we can get into this. Where we left off in this transcript. Part 1 we left off. We are in the meeting, the ex parte meeting with the judge, and they just went to get Mr. Copeland. who is the witness, who's on the stand. And so we have one more player in the conversation, and this guy is a hoot. Oh man, he's funny and he's smart. I think a lot smarter than he lets on. This guy is a smart kid. And
Woody is.
Yeah, maybe he's done some crazy things in his life. I'm not saying that's
no,
that's
and I think he'd hold his hand up to that myself as well. He'd say it himself too. But yeah, he's not daft by no means. He's on to exactly what's going on in this room.
Yeah, and it's not good. Honestly, it's not good for him. Any way this goes, this ends badly. And really, he's aware that that's the case. that everyone is not out there to help him. So okay, there's my scroll. I had to find out which. I have like 5 computers running. I couldn't tell which one was running the scroll wheel. I found it now, so we can begin. Do you want to kick off reading, or do you want to?
I'm okay. Can you remove the floaty heart?
I just did.
You're a sweetheart. Okay. There you are, Amber. I saw it, love. Just come up on mine.
If you see any, first of all, you're welcome to take breaks whenever you want. Switch off, or just say tag team go, and I'll pick up where you.
So we're reading it straight, yeah? Or do you want to be? Do you want to be?
Oh, do you want to play?
Do you want to be the cool guy, and I'll be Miss Love and Bumpus and.
We could split on gender. Yeah, we could split on gender if you want. I'll be the court and Mr. Copeland, and I'll try to do voices to differentiate between the two, because sometimes I'm talking to myself. And then you be Miss Bumpus, Miss Love, and maybe
Hilton. Miss Love's not in this one, is she?
Oh yes, she stepped out, huh?
She's gone now, isn't she? Yeah.
Yeah. Okay. Let's do that. Then. And I guess I can be the narrator as well. Or do you want to be the narrator?
No, I'll start. That's fine.
All right. This is good. What could possibly go wrong? I mean, really.
Let's go. I haven't got a very good Fulton accent, mind, but
you sound like you were born and raised in southern Georgia. It sounds beautiful. All right. The proceedings stood in recess from 9:34 a.m. to 10:03 a.m. Mr. Copeland enters stage left at 11:03 a.m. Also present were Judge Glanville, Assistant District Attorney Simone Hilton, and Attorney Keila Bumpus, Court Reporter Christina Weaver, who's silent throughout, investigators Antonio Long and Rashid Hamilton, and Deputy Houston, Deputy McPherson, Sergeant Brown, and Sergeant Hall with the Fulton County Sheriff's Department. Judge says, "Okay, Mr. Copeland, can you let him know I got a hearing problem?"
Okay. He said he's hard of hearing.
That makes 2 of us. I've got a hearing aid that's coming on the 27th of June. So I'll try and talk loud. Is it okay if I can read lips.
I can read lips.
Hey, don't steal my lines.
Oh. Well, that's a good blooming start, isn't it?
Okay, good. Mr. Copeland, good morning. Good morning. All right, I just wanted to bring you over here and let you talk with Miss Bumpus and see if there's anything that you need to ask of your counsel or Miss Hilton or the state or the court before we bring you out this morning, because we'd like to hear your testimony, and that is kind of where we are at this point in time. So is there anything you want to ask? Well, I want to speak to you personally that I have never been truthful a day in my life until I just made this statement right now. I don't comprehend none of this stuff that's going on. Okay, well, the only thing you can give is truthful testimony. I mean, whatever you know is whatever you know. I mean, that's it.
And what we'll say, and Mr. Copeland and we have talked about this. I'm not sure what your concerns are, what concerns that you expressed to Mr. Melnick last week. But if any of your concerns deal with being locked up for anything, you can't. Like, there's nothing that can happen. The feds. Well, that's not true. It is true. No, I said that's not his concern. If his concern is safety, we need to know that. Like, that's not expressed, so we don't know what the concern is. So that's why we can try to resolve the concern. This is what I'm saying. Mr. Copeland and I have had conversations before. I understand some of his concerns is potential criminal liability, hence why we gave you immunity that you didn't want to ask for, mine. The federal statute of limitations done. The state statute of limitations done. So there's nothing. Like, I researched it this weekend. Both the statute of limitations for what you and I talk about, which is in 2015 or before, done. You cannot be prosecuted for anything you testify federally or statewide. Immune period. So if that is the concern, there is none, because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything in 2015, 5 years ago, would have been 2020. And anything statewise is 4 years, and it would be 2019. Finished. Next concern, what may happen in the street? You know, what we've talked about, what we can do as far as living and all of that. You know, staying alive and that. We have had those conversations. So I'm trying to express to you, we do not want you locked up, all right? I don't know how many times I've got to tell you that. What I've got to say to you, we do not want you sitting in the cab or whatever they've got you because of this. I know you wanted to talk to me on Friday before you walked into court. We weren't able to talk. Remember that? If you still want to talk with or without Miss Bumpus, I'm here. But you do not want we don't want you in custody. You will not. But this order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution. Any of it, literally. Judge, you might want to close your ears, man. If you confess to a murder on the stand, if we don't have any other independent evidence outside of what you said on the stand, you're immune from prosecution for what you say in court. So again, I don't know what was communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in our private conversations with Mrs. Long, as I'm saying in front of Miss Bumpus, as I told you, that is what this order says.
And that is direct or cross-examination.
And that is direct or cross-examination.
I said that. So if you're worried about what the defendants may ask you, because you may know they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. I got family members watching this trial, and I don't want my nephew to hear the things that I may be involved in and think it's okay.
But I think that's a separate conversation you can have with them as an honest individual. Like, look, nephews, I've lived my life that I don't want you to live. Don't go through what I've been through. But that's something you can have outside of being in jail because that's a better conversation. You can have with your nephews in person, but they shouldn't have to come to DeKalb County Jail because you've been held in contempt. You can have that conversation with your nephews tomorrow in person. You can have that conversation with them. You can have that conversation with anybody. You know what's coming up this weekend? Why are we in jail? What are we doing?
But y'all did this intentionally.
No, we did not. You and I had this little conversation, Mr. Copeland, on Friday morning.
You knew my child's birthday was next week.
But what did I tell you? Doesn't deny it. But what did I tell you when we met with each other? I said to you, you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And what was my response? If you plead the fifth, and that is exactly what you did on the stand.
But what did I tell you before I got to that point? I told you the whole time, Tuesday, Wednesday, Thursday.
But I told you we were giving you immunity.
That I was pleading the fifth.
No, you did not.
I told you every day I was pleading the fifth.
No, you did not. And we told you.
I told you my concern.
And we said we would give you immunity. You said your concern is what they know about you. And when you said that, I said, well, you know stuff about them. And then I said, whatever your concerns, we can give you immunity.
So I didn't tell you I lied to them to get myself out of the situation?
You said you were a liar. That's what you said. You said you were a liar. Was this recorded? No. And did he ever say that Melnick was his attorney? No. This week, when we first met you in the car on Friday, we asked you, is Mr. Melnick your attorney? You said, he's not my attorney. I haven't even talked to him.
No, I never said he's not my attorney. I said I haven't talked to him.
You said he's not your attorney. You haven't talked to him. Then we continued to have a conversation. At no point did you ever say to us, hey, I want Mr. Melnick here. Hey, put Mr. Melnick on the phone.
You didn't make me feel like I needed him.
But if you needed him, we would have said if we would have needed Mr. Melnick, we would have said to you, okay, just call him. So I mean, that is our position. We don't want you in jail. We just want you to be able to purge yourself by testifying. Whatever your truth is what your truth is. But you've just got to answer the questions. We believe that whatever your truth is what your truth is. We know that what you said before. I don't know what you're going to say on the stand, but what we know is pleading the fifth is going to keep you in custody. That's what we know. Now, how you answer your questions is how you answer your questions. I know what you said before, and I know what you said later. I mean, I know what you said before, and I don't know what you were going to say on the stand because you and I never went into full details about it. But what I don't want you to do is be sitting here in custody.
You did it.
I did not do it. You did it by pleading the fifth.
You told me before you went to the judge with whatever the thing called you went to him with, you told me that I can't. When I'm asked a question, I can say, I don't recall or I don't know. You told me that if I plead the fifth, I mean something, why would I plead the fifth to something I ain't do? And I said that you don't know what I did and what I ain't do. And then you was like something, and then y'all asked for this immunity, and I was like, it was something. And then Thursday came, and then y'all go tell me, oh, we went to the judge with this, and you got to testify. If you don't testify, the judge gonna lock you up.
Right. But that was based upon what you...
But I told y'all that.
No, you didn't.
You said, why would I plead the fifth to something I didn't do? And I said, you don't know what happened.
And I said, I don't know what happened. Only you know and them know, I said. But you never said, I am pleading the fifth. You said, what if I do this? What if I do this? What if I do this?
I told you, I said, I'm going to plead you said, why would you plead the fifth to something you didn't do?
So if you didn't have immunity prior to, so if you didn't have immunity prior to, is that what you were saying, that you feel like he didn't have immunity prior to?
Immunity came Friday night when I went to jail.
The immunity only came after Mr. Melnick. Oh, hold on. The immunity came after Mr. Melnick sent us an email saying, my client is pleading the fifth. That was on Thursday evening at 6 o'clock. Okay. So after that, that was an emphatic, he is pleading the fifth. And we came and we got this signed. And then Friday morning came. Okay. So between Friday evening, Mr. Melnick reached out to us and said he represents him. He's pleading the fifth. Okay. And when was the last time you talked to him before Mr. Melnick got involved? Well, we talked to him earlier that day on Thursday. Okay. And then how did...
He called me.
Okay. I was just trying to get a timeline. Sure. Right. So we have been talking since last Friday. So I met with Mr. Copeland last Friday, I think out in the neighbourhood. Then he came on Tuesday for court. We talked briefly on Tuesday, and then on Wednesday he came.
Thursday.
No, I think he only came 2 days, so it had to be Wednesday and Thursday he came. It wasn't Tuesday, it was Wednesday and Thursday he came. And then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point is when we went the next morning and got the immunity motion. And then we spoke on Friday morning. I handed Mr. Copeland this agreement and let him know that he has immunity and that anything he says we can't use. And then Mr. Melnick came and then we had court. So you were pretty much saying you didn't ask for this?
I didn't.
But we gave it. He doesn't have to ask for it. I know. I mean, he's just saying, right, he doesn't have to ask for it. But to alleviate whatever his concerns were, we gave him immunity. He didn't have to ask for it. So if he wouldn't have had this, I'm just saying this so he can understand it. I'm walking him through. Would he still have to testify, or would he been able to plead the fifth? That's what he's saying. If he didn't have immunity, yes, he could plead the fifth.
That's what
he's trying to say. He's trying to say he didn't ask for this, but he doesn't have to ask for it now that we've given it to him, because that's on us. So now that we've given it to him as an order, he can still choose if this is the road he wants to take, then he'll just stay in custody until the trial is over. And when we say the trial is over, every last defendant has been tried, not just these 6, the other ones too.
I done did longer time.
All right, Mr. Copeland, I'm telling you that you are literally immune from prosecution from anything else you may say. That's that. So the choice is always up to you. But we wanted to put on the record that the state does not want you in custody. What the state would like you to do is purge yourself from...
What purge yourself mean?
Meaning that you are no longer in custody. And the way that you purge yourself is to testify. That is kind of how it works. And that is what the state wants you to do. We don't want you in custody. I can't say that in any other different way. We don't want you in custody. The only thing that's holding you is you refusing to testify.
So, do you have any questions or any other questions? Basically, if you invoke the fifth, I don't know what's going on. I don't trust nobody. I trust her word, but I don't know what's going on, Your Honor.
This is your insurance. I don't know if you want to break that down to him. Well, he doesn't want that.
But he's been given it. See, that's the challenge, Mr. Copeland. If they didn't give you the immunity, you could invoke the Fifth Amendment privilege. But what the state decided is they said your testimony is worth more to them at this point in time, and they really want to know what you have to say. So they made from a state's perspective, they made a decision to give you immunity, so you no longer can invoke your Fifth Amendment privilege. You have to testify. So that's the difference in this particular scenario, is that they have taken away. Well, you can still invoke your Fifth Amendment privilege. You can still do that. But the consequence of invoking it is you will just remain in custody. So if you testify, you get out of custody and you stay out of custody until you're done. And if I don't testify, I have to stay in until when? Until the trial's over. Until all the defendants have been, I've got these 6 that we have right now, and then there's another 6.
No, there's another 12.
Oh, there's another 12 or thereabouts that are still outstanding in various forms or another. Can I speak with her for a second? Yeah, sure. Judge Glanville, Assistant District Attorney Simone Hilton, Court Reporter Christina Weaver, and investigators Antonio Long and Rashid Hamilton left the chambers at 10:17 a.m. and returned at 10:33 a.m. My question is, I can ask you a question? Yes. So my question is, what I was just asking her was, if you ask me a question and you feel as in I was lying about it, you'll lock me back up?
No, if you so you were saying, you say I didn't talk to Demikion. Well, no, I can't talk about that because the judge is in you. Yeah, you were asking, for example, if you said before that the sky was blue and I asked you to understand what color is the sky, and you say I said it was red. I'm going to say no. Back before you said it was blue. Is that what you were trying to ask me? So explain the independent evidence. If he says he did something and you know he's not telling the truth, what happens? If he said he did something and he did not do that thing. Sorry, if he said he did something and he did not do that thing, if you believe he did not, so if you believe that he's lying about that, then no. If he admits to doing something on the stand, and he did not do that thing, I'm going to say, is this the first time you are saying that? And you have independent evidence to prove it wasn't him? Then what? Then nothing. What do you mean, like? So then he would be fine. Yes, but so you were okay with him if he got on the stand and said things that weren't true? No, I want him to tell the truth. What have I always said to you? I want you to tell the truth. I don't know what's going to come out of your mouth. I expect you to tell the truth. If you say something that is inconsistent with what you said before, then I'm going to ask about the inconsistencies. But I expect you to tell the truth. What you go on a stand and do, I don't know. I don't know what you're going to do. I want you to tell the truth. But I will deal with you. You saying something different in a manner than I normally do.
If I'm saying something different, right? So when the police question me, they done question me every time they lock me up. I don't know how many times that was. I done told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I done told them.
Okay, so then you say, I don't recall. Or, that's how it works. I don't recall. And you can say that to every single question. Well, I hope that is not the truth, because I think there are some things you do recall and some things you don't. But the things you don't recall, you don't recall. And then I will go through my process of what I do. You can talk to him about what impeachment is. That won't get you locked up. Impeachment will not get you locked up. You can talk to him about what impeachment is. If he says, I don't recall.
What will get me locked up?
What did I tell you?
I don't know.
What you did on Friday, I plead the fifth. If the court instructs you...
So the only thing that gets me locked up is pleading the fifth?
Yes. The court instructs you, you need to answer the question. You say again, I plead the fifth again. That's what's going to get you locked up. But if you answer the question, that will not get you locked up.
So if you don't want me in jail, why don't you just let me go after the trial over with?
You were in jail because you were not answering the questions.
Because you've been given immunity.
Because you've been given immunity. You were only in jail because you got up here.
Well, what about this? I answer the questions. You take away immunity. I answer the questions, and I plead the fifth.
No.
To questions that I feel incriminate me.
But then that's...
I won't plead the fifth to things that don't incriminate me. The state can still give you immunity. They can give you immunity to whoever they want, okay? And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure it's that the jury needs to hear what you have to say, good, bad, or indifferent. And what Miss Hilton is telling you is just tell them the truth as you know it and let her worry about, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. What will get you into trouble is you just invoking your Fifth Amendment privilege because you've been given immunity. Or as Miss Love said this morning, remember, Miss Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. That particular false statement. That's what they're going to do.
Can I just say, when did Miss Love say a bold-faced whopper? She didn't in the transcript.
Not yet.
It's missing. Oh. That is what I was saying. You'll be right back here. But if you say something that you know you did not do, like you admit to something you know you did not do, whether
like murder, don't have no statute of limitations, right?
But if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it.
But y'all don't like.
You can charge him with false statements and he will be back in jail. That is what I'm trying to say. But if I know that you were lying about that, I do not intend to do that. If I know, right, now he's lying, I know he's lying, I'm not going to charge you because I know your reason for doing that. But I'm not going to charge you when I know you didn't do what you're trying to say you did now. And that can be part of this. I know you didn't do it.
But it's up to the judge to do that.
No, it's up to the state to bring charges.
I don't have anything to do with that.
He has nothing to do with bringing charges. That's up to the state of Georgia.
Can I talk to my family and I'll make my decision right after I hang up the phone?
He's saying he hasn't been able to speak to anybody. His sister just called us.
Y'all done me wrong. Y'all just hold me in the jail. Don't let me get no PIN number, no nothing.
We have no knowledge. We did not know that he hasn't been able to do anything. Speak to anyone.
The jail system down, but y'all still putting people in.
That part, I don't know. I know we have been in communication with your sister. Your sister actually texted Miss Lancequot to make sure that you probably butchered that.
Yes,
to make
beautiful.
sure you were okay. We told her we physically had laid eyes on her. I'll leave that up to the sheriffs. I don't know.
So, what you think? What she's saying?
I can tell you right now.
I'm talking about that locking me back up.
We would have to bring charges. There would be no incentive.
Y'all will.
We've already had this discussion.
Look at what you did to me. You waited until Friday and did this. I done told you every day before Friday that I came. I was pleading the fifth.
No, you did not. As a matter of fact, our last...
Mr. Copeland, let's see if we can get beyond this, okay? Beyond what your concern is. You could have invoked the Fifth Amendment privilege. The state could have turned around and said stop and had me go ahead and filed that motion and given you immunity. I was going to, they make that decision. They decided to make it on the Friday. So even if you would have been more comfortable testifying and invoking your Fifth Amendment privilege, they could decide you as a witness, they want your testimony more than they want you to, you invoking your Fifth Amendment privilege. So they give you immunity. They gave you immunity. So you've got to testify truthfully as to what your knowledge of the particular incident is. So they could have done that anyway. Even if they put you on the stand, they could have said stop and gone ahead and given you immunity. They could have done that. So can I get in some type of writing that if I was to testify, that if she feels as if and I lied about anything, that they won't lock me back up? Let me have that, Miss Bumpus. Miss Bumpus, hands document to the court. Brief pause. Mr. Copeland, on page 2 of the order pursuant to OCGA 245507, however, no testimony given by Kenneth Copeland as required under this order or any information directly or indirectly derived from the testimony of Kenneth Copeland given by Kenneth Copeland as required under this order shall be used against said Kenneth Copeland in any proceeding or prosecution for a crime or offense concerning which he testifies under this order. Okay? So you testify about some aggravated assault or murder. They can't prosecute on it because that's what it says on the order. Okay? The only thing that will get you in trouble is this next little paragraph. Kenneth Copeland shall be subject to prosecution or penalty or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court in this state, the United States, or any other state. So basically, if you commit perjury, false swearing, or contempt committed in testifying, that means if you just invoke your Fifth Amendment privilege, or failing to testify, you say, I'm not going to testify. All right. So the only two real things that you can kind of get you in trouble for are perjury and false swearing, as long as you tell the truth. Now, as Miss Hilton and Miss Bumpus said earlier, you may have told or been asked about situations over and over again. They may have changed. What the state is asking you to do is tell the version that really is the truth. If they want to impeach you, they can do that. Or if the other side wants to impeach you, they can do that. You won't get in trouble for that. You said I will. You will not. You will not. Impeachment is not perjury or false swearing, okay? But she said I can purge myself, though.
No, no, no. We're saying two different things. Sorry. Perjury is if you get on the stand and you say just a bold-faced lie, just something that is just wrong. Say you say, I did something, and all the other times you said I have not done it. And really, well, it's perjury. It's really just an while it's perjury, it's really just an inconsistent statement. Like if you get on the stand and say, I did X, but in 2015 you said, I never did X. That is what I'm going to impeach. I'm going to impeach you on everything you said in 2015, meaning I'm going to say, okay, today you said I did X, but in 2015...
We have a security issue. We need to stop for just a minute. If we can stop for a second, please.
Judge Glanville and Lieutenant Dean exited chambers at 11:45 a.m. Judge Glanville returned to chambers at 10:45 a.m. They returned 2 minutes later.
Difference in those times is very important, the timing. I don't know what was told to you on Friday. I have no reason to want you in prison. You have spent enough time in prison for YSL, period. So why would I want that for you? So it's like the state's on your side, you know.
I imagine her wanting to give him a big warm hug about right now.
You have spent enough time in prison for YSL, period. So why would I want that for you? That doesn't make no sense. Any sense. I said it to you before, and I will say it to you again in front of all these people. It makes no sense.
You just said I'm going to have to stay in jail until the last.
If you don't testify, get this part through your head. If you don't testify, that is the only thing that is holding you. That is literally the only thing holding you right now is the fact that you keep saying, I'm not going to testify. Well, you haven't said it today. I'm not going to testify. I plead the fifth. But if you get up there and I want you to tell the truth, like I said before, if you don't recall certain things, you say, I don't recall. You don't recall. That's fine. I want you to tell the truth. I don't expect you to remember every single detail from 2015. I just don't. No one here does. But what I do expect for you to do is answer questions so we can get through this, so you can go home, be with your baby for her birthday, see the dogs deliver their babies, go talk to your nephews and do all these other things.
How do you know about my dogs?
Because you told me.
Okay.
What's wrong?
I'm stressing at another level. Like,
I mean, Kenny, I'm saying...
I'm weak, man. I'm not playing. I'm dead serious, man. Like...
This is what our position is. We do not want him in custody. We want him to tell the truth. We want him to testify. That's what will get him out of jail. And you have to make... If he decides in 2 weeks he wants to testify, then what? If he wants to stay in jail for 2 weeks, then that's... I don't know why you'd want to stay in jail for 2 weeks. I have no idea. He just feels like he's under a lot of pressure right this second.
Even in the jail, they're just, you can't give me house arrest?
No, you can't go home you can go home by taking the stand and testifying. That's what you...
And come back tomorrow.
We keep on saying yet. There is no crime yet. And we keep on saying yet. I don't know who's telling you about a crime. Something missing there, Scott. There is no crime. You have done nothing wrong except for not...
So why am I in jail then?
I don't know, because I can't see the right thing. Because you aren't testifying.
But that ain't nothing wrong. It's not a crime.
It's not a crime, but you're in civil contempt.
2 things. Because you invoked your privilege after you've been given immunity, that is why you're in custody, because you get out by testifying. So you testify, you get out. That is what I was going to bring you, why I brought you here today, just inquire about that. You can remain and hold your position of invoking the fifth or not testifying, but you will go back to prison. You go back to jail because you can't sentence me?
Sorry.
There's
no sentence.
Oh, I got
Got you.
Amber was waiting for this. She's keeping score of how many times we step on each other. There's no sentence. The contempt is compliance. They want your testimony. That is all they want, whatever that may be. I don't know what it is, Your Honor.
So listen, you were in jail for failing to testify.
For failing to testify.
Not for nothing else. There is no crime. You ain't done nothing. I don't know if people are telling you that we are going to charge you with nothing. We are not charging you. The state charges you. There's nothing we're charging you with. You were only in custody because you decided not to testify. That is it. Once you decide to testify...
Remember the word you were talking about? Purge? Uh-huh. Okay, you can purge right now. Purge. Get yourself out of jail just by testifying. I can purge and get out of jail? Yes, just by testifying.
Not perjury.
Purge, meaning you can get out of jail. You can get out of jail, out of custody, just by testifying. And what about the other one? The other word, the perjury. That's different.
That's different.
That's a different word, okay? That could get me back in jail?
Yes.
Perjury is...
It's not... what you were saying, it is not perjury. What you were saying is what we call prior inconsistent statement. As I guessed. Yeah, example that you gave me. What if I said I did something and I know you didn't do it and you said before you didn't do it? That's not perjury. That's a prior inconsistent statement.
Brief pause.
You've got to make a decision. So if he starts testifying today, he's going to go home today? He should, so long as he remains. But if you get up there and be like, if you get up to start testifying and then we get into it and you start saying, I plead the fifth, we're going to be back here again. But if he says he don't recall to everything, he'll be okay. I'm not advising that, but so long as he answers the questions, that's fine. So long as he...
I did these crimes. I'm telling you that.
Okay. I don't know what you were talking about, but I think... Are you saying you want to get up there on the stand and say something? Did you find out if he could talk to his family, no?
Another brief pause.
I mean... If it's okay, we got the sister's number.
As my attorney, you gotta...
Let me, if you all want to talk, let me just go somewhere where I can't hear you. The judge is over there, so just speak low so that he doesn't hear you.
Hold on. Judge Glanville handed a document to attorney Kayla Bumpus and exited chambers with Assistant District Attorney Simone Hilton, Investigator Long, Investigator Hamilton, and Court Reporter Christina Weaver from 10:53 a.m. to 11:28 a.m. Okay. All right. Mr. Copeland, have you had an opportunity to talk with Miss Bumpus, your lawyer, and Miss Hilton and the state's counsel? Have you got any other questions? No, Your Honor. Is it your desire to give testimony today? Yes, sir. Okay. All right, then. Do you all have some clothes for him?
I don't know. Let me go take a look. What size are you?
I can't hear you.
What size are you?
Little. We have a
large jacket for him on Friday. Large, over.
You had a jacket for him?
10-4. That's 10-4, good buddy.
Oh, but he can't wear large.
What size is your waist size? 34? 32. Chest, what are you? A 34, 36 chest?
Probably 36.
Not my chest. What do you mean? The size, boy.
What size are you? Small or medium?
Small or medium? They are going to try to get you some clothes so you don't have to testify wearing that jail uniform, okay? Y'all don't want to show the people how y'all did me? Look,
If we can't find clothes, then you may have to until tomorrow.
I prefer to go in like this.
I understand what your preference is.
Nah, don't hide it.
Can you make him put on clothes? No.
I want to go in like this.
Fine with me.
All right. Okay. You ain't going to try and lock me back up for this?
As long as you testify, we will get an order to get you released today.
Whose copy is this?
You've got to make sure you come back now. I want to be real clear.
When have I ever ran?
You have not. That's the only thing. You have not.
Whose copy is this?
That was ours. Do you want a copy? You can take it though. Okay. Do you still have yours or you threw it away? I'm going to give him both of these things so you can have at least some information. Okay. Are we off the record now?
Are we done?
Yes, I believe so.
Okay, we're good. See everybody downstairs in about 10 minutes. Remember, pinky swear, don't tell anybody about this meeting. Oh, wait, that last part wasn't on there. Proceedings concluded at 11:31 a.m.
Oh, that was fun.
That was a lot of fun. We didn't have a certificate from the court clerk, and that's it. Welsh Lady Reads, thank you so much for joining us for the reading of that. That was brilliant. For those that don't know, Welsh Lady Reads has a YouTube channel. Hopefully one of our mods can put this in chat. She has an amazing voice, and obviously the accent is just fun. She can read court, and it just sounds lovely. It sounds just amazing. Sorry, I have to put some chats on this. You can read like court documents, and don't make fun of me.
No, it's funny. No. It's funny. I love it. I still find it fascinating that you people like it. It's just me, my voice.
Amber kept score, stolen lines, RA1, Welsh Lady Reads 2. I think I won that round because it's golf rules as far as scoring goes. You want the lower score.
I did. I stepped on your toes.
Did we get a mod that's able to put Welsh Lady Reads YouTube channel in here? Welsh Lady Reads does read YouTube books on YouTube. Did you read The Wonky Donkey?
I did The Wonky Donkey. That was a very, very popular one.
You have not lived until you've read this or listened to Welsh Lady Read. I mean, it's a funny story on its own, but you've got to go give that a shot. While you're over there, please hit subscribe on the channel. She deserves it.
Thank you, darling.
Thank you so much, Welsh Lady.
Thank you for having me on, and thank you, Amber, for your help beforehand as well. Appreciate it. I'm going to join the chat then, Scott. You okay with that?
We're good. Appreciate you. Thank you so much.
Take care. Thank you, chat. Love you. Bye-bye. Bye-bye.
Oh, man, she is just wonderful. Thank you for just subscribed. I see that here. Oh, you can't see that very well. I have to do it on this machine. All right. Let's see where we are. There's Ricky, just subscribed. I need to ignore that machine over here. All right, so where we are now, we're on Exhibit C, and looking at the pages, we are almost 50% through. We're almost 50% through the document. Let's see what comes up next here and see what we want to do, because we're at just approaching 3:30. I'm not sure. I know we're not going to be able to get through all of this. I can try to go a little bit faster through some of it and read to you. But let's see. This is going to be. Let's see if we can get through this next document. See how long this one is. This is a transcript of the contempt portion of the proceedings before the honor. Oh my goodness, this is a good one. This is a good one. I've seen all these messages that people subscribed to Welsh Lady Reads. Thank you so much. She is amazing. She's been an amazing supporter of the channel, loves true crime, and perfect reading voice. So thank you so much. All right. This is a transcript of the appearance. Here's the cast list. Who's who. we've got a lot of people on behalf of the defendants. We've got all the attorneys. The main players in this one is going to be basically Brian Steele. Brian Steele's the main player. Obviously, we've got the judge, who is Love, Hilton. They're there for the prosecution. Judge Ganville is running the whole show. We have a couple other attorneys that speak up. I think Max Shart might speak in this one. Anyway, so they're all present. This is court, but outside the presence of the jury, I believe. So let's see. Okay, proceedings. The court says, counsels, we're going to go back on the record. Can you bring out Mr. Copeland, please? Mr. Steele says, I have a motion I need to make outside the presence of Mr. Copeland. The court says, you can make it now. Is he out? Deputy, he's out. The way out means Mr. Copeland is out of the courtroom. Mr. Steele says, the way I understand my constitutional obligations pursuant to the 6th and 14th Amendments to the United States Constitution and the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. What I found out just recently, this is not waived, that it is supposedly in chambers, this honorable court reporter at times, the honorable court at times, the district attorney and district attorneys for the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware this was going on. I was told, based upon information and belief, that it was told to the district attorney that Mr. Copeland intended to plead the 5th Amendment. Then I was told, based upon information and belief, that Adrienne Love, the lawyer for Mr. Copeland, and this court were together, and Miss Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Miss Love, to Adrienne Love, stating that Mr. Melnick does not represent the witness and that Mr. Elnick wrote in the email saying F you, and then somehow that email was CC'd to me. That never, the court says, Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that is ex parte. All that was an ex parte conversation. How did you find out about any of that? Well, I'm disturbed too. And the reason, the court says, I'm asking you a question. How? And I'm going to answer your question. Did you find out about it? I'm going to answer your question. Okay. Scudder. If you look at Scudder v. State, which is 298 Georgia 438, it's Division 2, 782 Southeast 2nd, 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assumed is somewhat accurate based upon what you just said. We're entitled, Mr. Williams, and every other person wrongly charged here is entitled under the Georgia Constitution to be present. And that's a critical stage. Well, it's just like when you met with me, you and Mr. Adams meet with me and others meet with me. Those were ex parte for a lot of different other reasons, but I will certainly note that for purposes of the record. Mr. Steele says, well, I'm going forward. What I was told was that Mr. Copeland said, you haven't answered my question yet. I'm not going to answer that question. You're not? No, I will not answer that question. Why will you not answer that question? Because I want to make sure that what I say is accurate. I'm not trying to, no. I'm asking you, how did you get this information? I'm not telling the court. What I'm saying is based upon information. Well, listen, if you don't tell me how you got this information, then you and I are going to have some problems. We can have, as I have problems right now. Okay, look, I don't want to know about your problems at this point in time. All I'm asking you at this point in time is, how did you come up with this information? Look, if the case gets reviewed, the record's going to be available for our appellate court, and for whatever reason, it's disturbing that somehow you have surreptitiously gotten information in regards to the court's private ex parte conversations with the party. I mean, a party? A witness who was sworn in Friday? The court's telling, this is what I was told. If this is not true, it's not true. This court handed Mr. Steele, after Copeland, tell me how you perjury. Tell me how you got the information. Listen, however you want to tell me, I'm not telling, how you got the information. When can we go ahead? Then we can go ahead and go forward. I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court, I was told, it concerns me that you have proprietary information. Why is it proprietary? Or information that you should not be having, which was ex parte with the parte. Why? The state of Georgia. How about the witness? How about Mr. Copeland, who has supposedly announced he's not testifying and he'll sit for 2 years? And then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. The shade that's in there. Then supposedly this honorable court, or excuse me, let me rephrase that. This court, he struck honorably. He's just dishing it out here. This court supposedly said, I can hold you until the end of this trial. Miss Hilton supposedly said, actually, all of the defendants, and then all 26 people are disposed of. If that is true, then what this is coercion, witness intimidation, ex parte communications. We have a constitutional right to be present for. So I understand that you're upset towards me, but I know what I did. I'm doing, Mr. Steele, I still want what everybody should do. Mr. Steele says, I'm doing what everybody should do, meaning all the other lawyers should. The court says, I still want to know how you did come upon this information. Who told you? What I want to know is why wasn't I there? Sir, I'm going to hold you in contempt if you don't tell me. I'm not. Who this information came from? I don't want to be held in contempt. I'm not answering that question. That is attorney-client privilege information. I am not answering that. Attorney-client privilege? Unless you were in my chambers, that's the only way you can figure out. I'm telling you what. I'm going to give you 5 minutes. If you don't tell me, you don't have to. If you don't tell me who it is, I'm going to put you in contempt because I understand that is not attorney-client privilege. Attorney work product privilege. I am not telling you. How did you get the information supposedly from my chambers? Did somebody tell you? I'm not. You should have told me. Court says, you've got 5 minutes. Well, I don't need it. I want to continue. You got 5 minutes. This is what I was told. We're in recess. Mr. Copeland, we're in recess. Mr. Copeland made statements. We're in recess. Thank you. Judge Glanville leaves the bench. Mr. Steele continues that he admitted to killing Donovan Thomas and don't take my notes. No. The proceedings stood in recess. Somebody took his notes. Court says, all right. Do we have everybody here? Sergeant Ingram?
Yes, sir. Everyone is present.
Okay, Mr. Steele, would you take the podium, please? Brief pause. All right, Mr. Steele, before I recessed, I asked you, how did you get this information? And it was not covered by work product. There was only one way you could have gotten it. So I'm going to ask you again. And I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have, 1.6. I know what the rule says, but here's the thing. Well, let me just tell you, but you've got to, my understanding, but in order, you have interrupt. You need to please tell me who you got it from. I'm not asking you the sum and substance of anything as of yet. Okay, but I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt. I understand, and I don't want to be held in contempt. And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious. Yeah, that's why I raise it. It is that serious that we should have been there and it shouldn't have happened. Sir, that is a whole separate issue. And that is the issue. That is why ex parte conversations are recorded. Why would it be ex parte? Because you act like it's ex parte under seal. It's ex parte because of what the state asked me to do. It's just like when you asked me, I have never, for an ex parte conversation, I have never asked this honorable court or any court to meet with me and a witness. Sir, tell me, you're straying off the issue. I'm not. I'm trying to. The issue is, how did you get this information? I understand the issue. I promise you I understand it. But what I'm trying to ask you is look at comment 5. This is how I understand the law. You cannot violate something and then use privilege. I'm not violating anything. Okay, but that is what I'm saying. How did you get the information? But just listen to what I'm trying to tell you. You're saying, okay, but see, you're threatening me with contempt. Listen to the privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't. Let me tell you, I'm just reading from it, but if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break. You're ordering me, maybe, or you're asking me. I'm not sure. You're ordering me to give you information, and you're saying that it's not sum and substance, but I'm telling you I can't do that under the bar rules. All right. Well, I'm going to hold you in contempt, and you can think about it. At 5 o'clock today, we'll see where you are, where you stand on that point, because no, that is what I want to understand, what I understand the rule to be. I have not asked you sum and substance of what was said. I asked you how you got it. I can't do that. Yes, you can, because I have an idea how you got it. Well, your idea may be wrong. I have an idea how you got it, but that is improper, sir. Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not going to breach that confidence. Sir, I don't want to hold you in contempt, but this is that serious. Judge, you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time. Judge, listen. And listen, I will do whatever you want until 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information and belief, from whom? Well, I would like to get the substance first, and then we can talk. Well, you will be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You have already kind of given us some snippets of what was said. That tells me that somebody parroted that information to you. So, but you're assuming something because I told you already. Well, then I can't answer that under attorney-client. If you were sitting, unless you were sitting there with the recorder, or Miss Love or Miss Hilton or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there was only one other person that is left. Well, Your Honor, and if that person gave you that information or shared that information with you, she probably violated privilege. Well, let me tell you two things. One, I don't know how that is privileged communication. It shouldn't have been ex parte, because she is a client and she has a client she's supposed to represent. Who are you talking about? But anyways, when I got this information, I'm not going to have any further conversation, well, with you about this. I want to know, the question still remains. I want to know who gave you this information? I'd like to know what information happened outside of us. That's really it. He can go into custody at this point in time. I think that the court needs to again declare a mistrial based upon, okay, and I'm going to deny the court, I'm going to deny your motion, I understand that your motion for mistrial spoke with a witness outside of our presence, a sworn, yes, and I had an ex parte conversation, which is appropriate, and you influenced the witness based upon information and belief, and I would like to have that on the record. All right. I mean, I don't know why that's so hard to do. If something happened bad, that's fine, but you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside our presence we can't have an issue that was outside our presence and that should not have been, because you got some information that you shouldn't have gotten. Why? Well, that's for another day. But why? Okay, that's for another day. Why were we excluded in the first place? I didn't know about this. That is for another day. To raise it before the court, I raised it as soon as we found out about it. Well, I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a critical part of the case. When a judge speaks to the witness outside the presence of the accused, the court has said it's right there in Division 2. That it is a mistrial or critical part of the case, and it's an automatic reversal. Mr. Steele, but you were acting like Mr. Steele. It's private. Mr. Steele, that is not the case when somebody discloses information in an ex parte conversation that one of the parties lawfully asked me to hold. You're not supposed to have communication with a witness who has been sworn. I'm not telling you. I'm just saying, if you read, I'm assuming you read it. That is what it says. And you did it. Supposedly. Does the state wish to be heard? I can't do Miss Love's voice. Yes. You said it supposedly. Yes, Your Honor. And that's what I'm trying to get to. The state does. That is what happened outside your presence. And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so that we can really understand it. And then anything that is not on the transcript, if anything, that we understand happened outside our presence. Okay. And now you have to put it somewhere, somehow I have to reveal. And I told you the first time that I would be breaching 1.6. I know you're assuming something. I don't think you're breaching 1.6. You can't hide behind 1.6. I'm not hiding behind anything. You can't hide behind. The thing is, I think that you got this information. Somebody disclosed it to you, and that is the only way you could have gotten it. Mr. Steele, or Mr. Steele said, what I got, unless you were sitting there eavesdropping. So you can't use something something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or a party didn't give you the information. So, Your Honor, that is the issue, isn't it? Well, why aren't we entitled to the, but isn't that the issue? That leads to be told. But right now, do you have any, we don't know, Mr. Steele, why were we excluded from that? Mr. Steele, and I want the information. Stop. Because Mr. Williams, just stop. Constitutional right? Just stop. Under the Georgia Constitution. Just stop at this point in time, because Article 1, Section 1, Paragraph 12, because you already said that of the Georgia Constitution, and we have a right to be present. All right, mister. And we're not waiving anything. Madam, Miss Love, thank you, Your Honor. And, Your Honor, I know I said this previously. Yes, sir. But we're not accepting any proffers. Oh, gosh. For Miss Love. Okay, excuse me. Okay, all right. Yes, ma'am. Your Honor, I am disturbed by Mr. Steele's representations to the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we had requested as the state to be on the record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know what that reason the counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate, what he calls, fact, and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That is why we asked that the court reporter be present. This is a matter that the defendants did not have a right to be part of, as this was a matter regarding a civil contempt that the court imposed on a person for not obeying the court's directive. The state read, and the case that the state Mr. Steele cited, it does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we will provide that to the court. But we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that did not happen. And we expressed on record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I would be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days. Well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of the number of people that I'm not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask the court strike everything that he said from the time he stood up and started talking after the court asked him where it was he obtained the information that was made privy in counsel for this court. All right. And regarding Rule 1.6, Your Honor, we read 1.6, and my understanding there, 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is the information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment. All right. Brief pause. And, Your Honor, regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when the information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask the opportunity to present the court additional appropriate remedies that we believe are viable. All right. Mr. Adams chimes in. Your Honor, may I be heard? Ms. Love. And, Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity of someone who has been held in contempt, Mr. Steele just argued whatever it is they are trying to argue based on information we believe illegally obtained. From the court's chambers. I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams. All right. He has 2 attorneys. Yes, he does, but The court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented at least at this juncture by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that this court is engaged in behavior that I believe comprises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that full investigation can be made as to what we believe has occurred here. So I take the same position of Mr. Steele. I am asking for a mistrial as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based on the information that we received. All right, sir. And frankly, I don't believe the state has any say in that. My statements are in regards to representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I'll have exactly the same position. I also do not believe that. Well, I asked him, so I didn't ask you. Yeah. Well, but we'll leave it at that, okay? Mr. Sharp. May I be heard, Your Honor? What is it, Mr. Sharp? Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I'm going to be moving for a mistrial first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at 8:40. We did not start until approximately, I'm estimating, 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And in the dark, quite frankly, we kind of remain in the dark. I'm not a false accuser, okay? I do not just go willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes. It appears that there was a meeting that I knew nothing about that involved, Your Honor, the district attorneys and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. That was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor, a witness in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for, as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in and we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I'm moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that is our stance, Your Honor. Thank you. I have noted your motion for mistrial. It is denied. Are you, same thing, you want the Harvey, Mr. Weinstein says, I'm joining Mr. Hart's motion for, okay, all right, for mistrial, Your Honor, and I'm adopting all his statements. All right, Mr. Matthews, Sr. Good afternoon, Your Honor. Carlton Matthews here on behalf of Mr. Marcaveus Huey. Okay. We are also adopting all the arguments that have been made by Attorney Brian Steele, the Attorney Keith Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also, Your Honor, we were here at the appropriate time, and when the court did come out, we were not made aware that there had even been ex parte communication that was had on part of the that was on the record, just in the point of letting the parties know that there had been this particular meeting. I had my suspicions that there was something going on, but I could not reduce that to a fact. And when the court came out, the court just got started, Judge. And we believe that based, again, on ex parte. We don't have to know the substance all the time. Just the fact that there was a meeting, Your Honor, we would have just at least put us on some notice there was something that was going on even beforehand. I thought that would have been the appropriate move. But nonetheless, Your Honor, I'm asking the court for a mistrial. I believe that is appropriate here under these facts and circumstances. Thank you. All right. Motion for mistrial denied. Mr. Williams. Angela D. Williams for Rodalius Ryan. We're joining in and adopting all of the motions. Thank you, ma'am. Madam, motion is denied. Mr. Gardner. Mr. Gardner for Mr. Nichols. We too adopt all the arguments raised by the other defense attorneys and motions. Okay, so noted. All right. Okay, Mr. Steele, last time, who told you? I have the same answer. All right, Mr. Steele's in custody, and once he clears the area, we'll go ahead and get started. And if my, I think it's Mr. Adams, I forget whose voice is what. If by the court means we'll get started resuming the trial, Your Honor, yes, that's what we're going to continue. I'm not halting nothing. I'm not going to participate in the trial without Mr. Steele and without, you don't have the luxury at this point of time in time, sir. You don't. Without the court addressing, you don't have that luxury. You don't have the luxury at this point in time. You don't. Without the court addressing the issue that we believe is germane to, sir, y'all are really getting yourselves cross-purposed at this point in time. I don't believe so, Judge. Sir, I'm telling you, you at this point in time, you made some things out of nothing. I think that you're on a very precarious ground at this point in time. So I'm telling you at this point in time, he is in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Respectfully, Judge, I will not. Say again. Respectfully, Judge, I will not. I cannot properly represent Mr. Williams until this issue is addressed. You're going to have to do the best you can at this point in time because you don't get to extort the court. This is what you're attempting to do. You're trying to, I'm not going forward if I don't get this. It doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you as the court under these particular circumstances, everything will come out as it should. I don't think, not if the court doesn't address it, and the court has refused to address it. Sir, I don't have enough information at this point in time to address it. We don't have the information. I don't, but I'm telling you at this point in time, there is nothing that was said that whatever this morning, if there is any accuracy to some of the information that we are, but sir, I don't even know your co-counsel won't even tell me who said whatever. Okay. Blah, 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 blah. And the challenge that I'm having in this particular circumstance is that it's such a violation of the sanctosactness of the court's chambers and the ex parte conversation. You're just glossing over that. You're glossing over that. I think the court in its entirety is glossing over the fact, no, that it's a violation of Mr. Williams' rights. It's not, sir. What happened and we believe occurred is not how, that's not what, unintelligible. That's not what happened. Not appropriate. That's not what happened. I'm just telling you, that's not what happened. Judge, respectively, we are not obligated to simply accept that there has been no violation. We believe that there has been, and the only way, okay, well, then you made, whether or not we get a transcript, well, then you've made your, no, we're not doing this at this point in time. You will have a choice to make. Okay, take Mr. Steele into custody, please. I am not proceeding without us being heard on this issue. Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of circumstance? Okay, all right. May I say one thing, Your Honor? Yes, you certainly may. Mr. Williams does not wish to go forward without me being here. You're removing me against his will and my will. You're taking away his right to counsel, and you're conducting material parts of this trial without me present, and I can't learn about it by watching it online. So for that reason, additionally, I ask for a mistrial, and I assume you'll deny it, but I would like you to deny our motions for mistrial. You denied the other people. I denied your motion, but I'll certainly take that under advisement, sir. We're going to be in the recess for the next 5 minutes. Brief recess. The court says, tell Mr. Adams to come in so I can put things on the record, please. Brief pause.
Your Honor, Mr. Adams is present.
Just hang tight, sir.
All right,
Oh, sorry, that's not him. That's the court. I messed up. All right, Mr. Adams, let me address your first refusal to go forward. We have had plenty of circumstances in this trial where you have been lead counsel and where you've done more than a yeoman's job representing Mr. Williams, and I don't doubt that won't continue. So you don't get to have your entire defense team here. You certainly get competent counsel, which the court finds that you are in this particular circumstance. And an appellate court will review my decision for abuse of discretion. So I'm going to direct you that you continue to represent Mr. Williams. You can consult with Mr. Steele at any breaks or anything such as that. I'll allow you to do that and continue to do that. But Mr. Steele put himself in this particular position in terms of, I'm not asking him for any other, or you, for any other information that might be privileged or any other conversations. But I need to know who told you, because that then derives other things this court needs to probably do. So he is the reason as to why we're here in this particular circumstance. So if you or he want to disclose to me who told you that, I'll be more than happy to reconsider. Well, you know, I know Mr. Steele will not. I also will not. And I respect this court. I respect the court has to do whatever it believes appropriate. But I would ask the court also respect my representation of Mr. Williams and standing for him when we believe there has been a violation that affects his right to a fair trial. And we believe it is the position we're in. And I would respectfully decline the court's order for me to continue forward at this time. Your Honor, may I address the court? Sure. Thank you, Your Honor. There are two things at issue. And one of them, Your Honor, is that can I ask the court how it is that the state has any position in this particular conversation between the court and myself? Before we recessed, Ms. Love said she was going to research this ethical issue because it is an ethical one. So just much like you add to it, I'm asking the state if they wish to add to that as well, sir. Okay. Thank you, Your Honor. Your Honor, we believe that there are two matters at issue here. One, obviously, Mr. Williams' right to counsel of his choice during the trial of the case. We believe that the court has the discretion to fashion any remedy, any punitive remedy for contempt that it chooses. We would ask that the court fashion a punishment for contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels, for Mr. Steele to be present in the courtroom. He can still be held in contempt, but for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial. We believe that it will, that so far this issue alone has needlessly delayed the trial of the case, and we believe that it may be in someone's best interest and in others not in their best interest for that delay to continue. So we would ask the court, notwithstanding the finding of contempt, allow both Mr. Williams, both Mr. Steele and Mr. Adams to be present while the proceedings are going on and while court is in session physically. I think that would be appropriate under the circumstances. And Mr. Steele, certainly, I can inquire about before the end of the day if he wishes to disclose that information that I asked him, and then he can certainly purge himself out of that contempt. So yes, that's fine. We'll go ahead and do that. The second thing I wanted to put on the record is that there was no substantive communication with any witness in this case outside the presence of counsel for the defendants or any defendants in this courtroom. The matter, Your Honor, if I may finish, the matter that the state requested an ex parte audience with the court regarding is a matter to which no one to my right was a party. It was a civil contempt matter, and the parties towards that civil contempt, the state moved the court to compel someone to do a thing. The court compelled. The state said, Your Honor, we're asking if they don't comply, that the court hold that person in contempt. That was a civil contempt matter. Nothing substantive was discussed. Everything was recorded, and the representations made by at least persons who were present to the state is that when questioned or queried about what was that person was told or asked whether things occurred, and that person relayed that no substantive communication took place during that meeting. So that is the second matter. And first and foremost, we just ask that the court, again, allow both counsels for Mr. Williams to be present when the court is in session so that we don't delay these proceedings further. All right, that's fair enough. Thank you. Your Honor, Mr. Shart, the ability for the state to paint themselves as a victim. Oh, that's the judge's voice. We need a different one. I'm dying. I'm dying. My brain is already turned to mush, guys. I'm not even sure if I understand the words that I'm saying. Mr. Shart's voice is gonna be Australian or something. I can't do an Australian accent. Your Honor, the ability for the state to paint themselves as the victim constantly in this matter is unbelievable. The court reporter says, can you turn on your microphone? We can't hear you, sir. Lally, a little louder. Court says, sir, we can't hear you. Mr. says, my client, Shannon Stillwell, and these other young men, fine, upstanding young men sitting here as defendants, are the aggrieved parties. We were not present. I would like to reiterate, but here's Your Honor, can I just... Mr. Shart, here's the challenge. You got the information in a way that was not lawful to begin with. Sir, that doesn't alleviate the information or make it less valid or invalid. So because we record these conversations so they can be reviewed later, we didn't have any conversations that were not recorded. And if you heard of other conversations that were made, I don't know how you would have gotten them otherwise because somebody had to tell you. Okay, well, all that's great. But like I said, this is what... And if there was a case, if and when this case gets reviewed, an appellate court will make those decisions. But at this point, my client is the aggrieved party. He was not present. That violated his Sixth Amendment right to be present. Okay, and that is your argument, sir. That is your argument. That is your argument. And another thing, Your Honor, that is your argument. All I'm asking for is some sunlight to cover over these proceedings. Sir, this is not an open meeting. This is not a sunlight situation. Release the transcript, and then we can see, because we do not accept Ms. Love's representation. Okay, you don't accept the court's representation? I'm telling you, I would like the transcript. I'm telling you at this point in time, when the case is reviewed on appeal, if I am wrong, then certainly the appellate court can tell me, and certainly there are other bodies in Georgia that certainly my conduct can be reviewed by. But at this point, I'm telling you that that's the sum and substance of it. We are trying this case right now to win this case. We are not playing for an appeal. We would like a fair shot at this case right now. We would like the transcripts, where we all know the appellate process in this case is probably going to take decades. Okay, well, at this point, so that is, like I said, I need to have a little bit more information in order for me to kind of make some other decisions in this case. I'm not saying that you may or may not get that information, but at this point, there is nothing that was improper about the ex parte conversation. The court is more concerned about the disclosure, and I understand the court's concern as to the counsel for Mr. Stillwell. My concern is the meeting that he was not allowed to be present for. Okay, all right. Thank you, sir. Your Honor, are you going to repeat the same thing again? I'll try not to. Let's try not to, because Harvey rules in effect. I understand everyone's opinion at this point in time. Judge, the only thing I want to say, and not to be repetitive, but on Friday, Your Honor, this particular witness, he came in, he pled the fifth, his lawyer was present. His lawyer stated to Your Honor that he had spoken to this witness, his client, and he stated that the witness indicated that on Monday, he will also be saying that he will plead the fifth. And then, Your Honor, there was a 2-3 hour span this morning, and then he comes in and says, I'm going to testify. That is why I believe, on behalf of Mr. Huey, that the transcript is important. Thank you, sir. All right. Well, thank you, sir. All right. Let's get Mr. Steele out, please. You can tell him to put his tie back on. We're going to be in recess about 10 minutes, and then we'll go ahead and get started at that point in time. Proceedings stood in recess. Counsels, if you would collect your thoughts, take your seats. Mr. Steele, in the interest of your representation, continue your representation of Mr. Williams. It's been brought to the court's suggestion that you be here at all open sessions of court until we finish for the day. So I'm going to hold you in contempt. You can purge that contempt by just telling me who it was that told you this information. That is all I need to know. But at the end of the day, I'll ask you that question again today. We did not take up any business in your absence other than Mr. Adams eloquently saying he was not going to go forward without you present with him, and not going to divulge who the information came from either. So with that, sir, we're going to go ahead and continue. All right? Can I ask a question? Yes, sir. Did the court order the transcript so we can see it and have a hearing with all the witnesses? I love Mr. Steele. No, I'm not going to order the transcript as of yet, because if the case should be reviewed, the appellate court will have that particular ability to do that. I don't believe at this point in time it is the court's understanding of the ex parte conversation that the disclosure is the more troublesome remedy. If I did something wrong, then certainly that can be reviewed. But I'm not at this point in time going to release any of the transcripts in terms of what may be disclosed or what was said in chambers ex parte at this point. Hello, Kitty. Thank you very much. Appreciate the kind words. Congratulations on 11 months. I love it. Mr. Steele says, well, I was told, based upon information and belief, that it would affect this witness's testimony in front of the jury, because I was told, based upon information and belief, that depending upon how the day goes, he may go home or not, depending on his testimony. I'd like to know what that is about. I don't know, Mr. Steele. I don't know. That is why I would like to know who it was that told you or disclosed this information from chambers, because I don't know if this person if that conversation was even had within my presence or hearing. I don't. That is a lie. That is a lie, according to the transcript. So I would like to have a hearing with the court as a witness, with the DA as a witness, and the deputy as a witness, with Mr. Copeland as a witness, with his counsel as a witness, and with the court reporter transcript. And Judge, I'm not trying to be harmful. I'm Mr. Steele. I think you are running a very thin professional responsibility line. I don't think you have cover at this point in time. I think that you have blown your coverage at this point, because I do not think that somebody told you some things that violate privilege. What privilege? Attorney-client privilege. So how do you get... but that is beside the point at this point in time. We're not going to argue about that right now. I just need the way to purge your contempt is that you tell me who told you this. That is, I'm not asking you what you said. But you are indicating what was said. Mr. Steele, yes. But I want to know who told it to you. I'm making it based upon information and belief. But I need to know who it is, because that is critical for the court taking remedial steps at this point in time. You're holding me in contempt. No. Yeah, I'm holding you in contempt because you won't tell me who. How could something, I'm not trying to be obstructive, but how could something be attorney-client privilege if it happened before the court, the DAs? Well, because if someone is represented party and they disclose information to you all as parties in this case, that could be a problem. That could be a problem. Like I said, I don't know what was said to you. So you don't know? I'm trying to get well, that's improper at this point in time. Why? Because you're telling the court conversations that you are privy to in my chambers that I know you weren't present. But the court was present. That's what I'm trying to say. That doesn't make a difference. But you got information you shouldn't have. And then you turn around and say, well, I did something. The court did something wrong, and we should be entitled to have the transcript. Y'all have contorted and perverted the particular process. You really have. Well, what I said was it is material part of the trial. It's not. That Mr. Williams had the right to be there at, and I'd like to exercise. It would be just like if y'all had had ex parte conversations with the court. And I don't say it about for what. You and Mr. Adams and others. That is your right. That little conclave discussion with the court protects you and protects the system. It is recorded and taken down so if it needs to be reviewed later, it gets reviewed. But you have made something out of it where I'm kind of at a disadvantage at this point in time because I didn't invite you into that particular proceeding and I don't think you had the right to be there. Well, all I know is that I told you there's more. Okay, well, there's a witness testifying who met with the court and DAs. That doesn't concern us. Your Honor, meaning the defense. I think that for the ex parte conversation in terms of what was said, I'm not going to keep continuing to discuss this because the transcript is what the transcript is, and it will say what it reflects. It really will, and the court will stand by that. But the other conversations that you may have, may be privy to or may have been disclosed to you, they are troubling. They are. And that is why I've got to find out who it is that disclosed that information. So you have the keys to your own contempt. I don't want to hold you in contempt, sir. I don't. I'm not asking you to tell me what was said between the two of you. But I do need you to know who told you. So if you're telling me to tell me, if you're willing to tell me, that's fine. That will purge your contempt. If you don't want to, then I'll unfortunately have to waiting to get that information. So you can let me know. Did the court put us in an order? In terms of what, sir? My supposed contempt? Your Honor, it is criminal contempt. It is sua sponte criminal contempt, sir. You don't get to appeal from this. You will go into custody at 5 o'clock today or wherever we finish if you don't tell me what that is. Tell me who that is. That is criminal. This is criminal contempt. I have asked you a question related to these particular proceedings. And if you don't tell me, then you will suffer the consequences of that, unfortunately. Like I said, I'm not looking to hold you in contempt. I really am. I'm not. But this is that important. It is important. Okay, so you have to think about it, all right? Can I last thing, going forward is over objection because I believe that we're entitled to the information, especially with this witness. All right, sir, I'll note your objection and it will be continuing objection for the time being. I may make some other remedies depending on what information I find later. On behalf of Mr. Stillwell, I'm going to renew our Brady demand for any Brady material that came out from any conversations with Mr. Copeland between Mr. Copeland and the district attorney's office this morning. All right, summon our jurors, please. Testimony continued. Mr. Copeland and the jury were released at 5:58. Okay, Mr. Steele, are you willing to tell me at this point in time who it was that disclosed this information to you? Unbeknownst to me, GACDL is here. They are not being allowed into your courtroom. I presume they are outside, so I'll wait on them to come in. I'm asking you, sir, because the contempt is for you. It's not to the Georgia Association of Criminal Defense Lawyers. Well, I didn't call them, but I mean, let me finish, okay? Because you said to me that you figured out somebody told me this information and somehow said that it's privileged, which I can't imagine, or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. You told me it was a criminal offense. And so lawyers just showed up because apparently I'm part of a club that includes free representation. Court reporter says, can you turn on your microphone? Mr. Steele says, they brought down lawyers. The lawyers are not allowed into the courtroom. No, or they're not in your courtroom. We just don't have any space, Mr. Steele. And plus, they are welcome to go to 8H. I mean, I told Sergeant Ingram that we can let in as many as possibly can. And that will fill up our benches at this point in time. That won't violate our security protocols, but that 8H is available. And 8H then has to have a right counsel. 8H then has to have a right to counsel because they are here. And I'm not going to. Do you have an attorney that is here for you, sir? Sure. Elisha Merchant is here. She's the president of, okay, all right. We'll let Miss Merchant in. Criminal defense lawyers. Alicia Merchant entered the courtroom at 6:01. Miss Merchant, good to see you as usual. Good to see you, Miss. Good to see you, Judge. She's got a high voice. I didn't notice that. I have told your client you represent Mr. Steele. Is that correct? Yes, that's correct. For the purposes of contempt, I entered the contempt order already. I'm entering an order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He has been disclosing that, however, and that is why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he'll be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there is no supersedis bond. There's no appeal. And I'm going to put him in custody for this evening. And if he wishes to, which he can still purge himself, if tonight Keith Adams emails me or you email me and tell me, well, it was X, so he can. I'm going to give him such a flexibility as to purge himself of this contempt. Only thing I want is because of the way of this information was disclosed, it is troubling to the court. Since this was an ex parte communication. I won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that is the only thing I'm trying to do at this point in time. So I asked your client for the last time if he will tell me who it is that disclosed this information. Judge, can you come up to the microphone? Says court reporter. Judge, just for the record, so is it criminal contempt you held him in? Yes, ma'am. Okay. And you said you had a hearing earlier today? No, with criminal contempt, I told him that the contempt was what the contempt was, and he refused to tell me. Order of the court. Counsel, as you know, if the court orders you to do something and you don't, that is criminal contempt. So I've asked him several times, please just tell me who it was that told you. I didn't ask or inquire about anything that was said. I just want to know who it was because he's got too much detail of this particular alleged conversation for the court to be concerned about it. Judge, since it is criminal contempt, he's entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And notice the court, criminal contempt is different. It is on the spot. So he's gotten to the due process. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that. So a little different, Miss Merchant. I'm going to disagree with you. And Judge, just for the record, that is direct. So that way you're holding him in is in direct criminal contempt? Yes. The issue with direct criminal contempt is that whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is that if you hold him in direct criminal contempt, not attempt, as you were saying you did, you are a witness to that proceeding. So it has to be referred to another judge. It doesn't require a recusal. You actually have to sua sponte send it to another judge because you are a witness in the proceeding. Show me the case law that says that, Miss Merchant. Yes, it's in McLarty. It's 151 Georgia, APP 399, and it says that this is one of the cases. Also, two other cases in Adams, whatever. Hold on a second. Give me the name of the first case again. In what? Do you want just the number, Judge? Yes, that would help. 215 Georgia, APP 372. Okay. Also, 215 Georgia. This is the Adams and Hasty. Let me take a look at those. Brief pause. Do you have anything a bit more current than 1994? Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older, but I do have other cases. And Judge, I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20 or 25. Oh my goodness, she is a firecracker. The challenge is I have space allocations, as I told you. You can, like I said, since you were representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns as well, we have to vet people to come in, and they can go to 8H, and they can certainly watch the proceedings from there. Okay, and Judge, for security purposes, they are all attorneys. They are all members of the bar. I can give you all their names. They would still have to be searched and still would have to be subject to the court's protocols. And also, there's room in the jury box, and then there's room in the courtroom, so we would ask that they be, I don't want anybody in my jury box, okay? No. I understand. May one additional attorney come in at this, then? Alex Souser. And we're here on behalf of GACDL for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also the member of the strike force. So can he come in as another attorney co-counsel? Yeah, certainly. May, sure. Great. Thank you, Judge. in Adams, it has two issues. One is the motion for disqualification. Okay, and that's, I think the judge went ahead and did some other things that caused there to be the issue presented. So I don't believe Adams. I'm going to take a look at the other case. That was in Adams. Yes, I'm going to look at the other case in just a second. And there are several others if you're ready. She's got all the facts. My goodness. Hasty's conduct didn't raise to a level to necessitate a warrant or warrant contempt by the court. That is the difference with Hasty in this particular case. So I distinguished your two. Oh, this is the court's voice. Hasty didn't conduct or rise to a level to necessitate or warrant summary contempt by the court. That is the difference with Hasty than this in this particular case. So I distinguish your two cases that you have given me thus far. Those were only two. Those were only the initial two. I have had a couple others as well. Go ahead. Ramirez v. State. It defines direct contempt and explains that it must actually interfere with the proceedings to be direct, which there is also a couple other cases on that. See, but y'all are covering under, let me see. I'm sorry, Judge. Hold on just a second. Ms. Merchant, in Ramirez, it even says if the contempt is direct, the trial court has the power, after affording the contemptor the opportunity to speak in his or her own behalf, to announce punishment summarily and without further notice of hearing. I already did that with Mr. Steele. He already told me. I already gave him the opportunity to do that. So we had the conversation this morning already. So, and Judge, so there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying you had the hearing earlier, but regardless, he was entitled to have an attorney at that point, and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I cited, along with some others that say this, that a summary proceeding is not necessary in a case like this. And the best evidence of that is that trial has continued. If it has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case. Oh, I can tell you, because it's a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. And as to how that information was disclosed, that is a problem. That is a real problem. That is why it is such an issue for the court at this point in time. Judge, Mr. Steele has a right to make a motion like this. If there were ex parte, he does. I'm not saying anything, but he's kind of put himself in a particular position he's in. No, Judge, I don't agree. I believe that I'm going to disagree with you. I believe that the court has put him in that position. No, he cannot be held under this law states McCartney, which I cited to you earlier. It is true that the direct summary contempt, which arises in the presence of the court and tends to scandalize it and or obstruct the orderly process of the administration of justice, the preservation of an order of decorum in the court is exempt from due process requirements of notice and hearing. And that's even in Moody. It goes back to 1974. So I believe that Mr. Steele, and he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations. I just want him to tell me that. And Judge, so that is what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt. So you can come into court, Miss Merchant, and not answer a question of the court and not be held in contempt. If it's a question that the court is not permitted to ask, yes. Okay. Well, this is a question the court is permitted to ask. And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege, again, answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You were a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them by nature. You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also summarily, but you got the information. Here's the thing. You got the information allegedly from improper methodology. I'm not saying he eavesdropped. I said that is one of the things. One of the things is it's either one of two ways. He either eavesdropped, which I don't believe that he did at all. I don't believe that for a minute. But I do believe that somebody did tell him that was the sum and substance of the court's conversations, and that would not be permissible. Judge, let's just back up for a second. He makes a motion because he has a reason to believe there were ex parte communications made. The court has a duty, if there were ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it. I think he caused that particular circumstance. I think he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion, I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me? Yes, Judge. There's quite a few other things. So first of all, we would like to ask you to be recused from this case because you're a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you're a witness to this proceeding. Therefore, to the contempt, you're a witness to the contempt. You have now, if it's criminal, which you are saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair trial, fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whether rule it is in the court, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways. I'll let that appellate court decide that. So anything else? No, we'll file a notice of appeal, and we need to have that order reduced in writing. I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has, in fact, filed, and I will note this as part of the record in this case, he has filed a motion to set aside the contempt. He's filed a motion for a supersedeas bond, and he's filed a notice of appeal, all of which I include as the court's exhibit in order, the next court's exhibit in order. But I'm reducing the contempt to writing, and I mentioned earlier he can purge himself of the contempt just by telling me who it was, and he can do that this evening, or he can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday. And Judge, we would ask that you grant the bond at this point, grant him a bond on that issue. You don't get a supersedeas bond on a criminal contempt, though. You can grant him a bond. No, you don't get one on that one. The civil is the one you can hold him until he complies with the order. I'm sorry. I think in the case law on that is regarding Hughes, R.E. Hughes. Hold on. The supersedeas bond requirement does not apply in a contempt that is in the presence of the court during the process of a proceeding. OCGA 5613 Bravo. So if you don't get a supersedeas, on a criminal contempt, respectfully. Mr. Souser, okay, he's the other attorney who was led into the room. I guess he started talking previously. I've been using the girl's voice. I'm sorry about that. Sorry, Mr. Souser. My apologies. I think Mr. Souser must be from Texas. So, Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt? That's correct. Judge, the reason I'm asking is because in Hughes' case, which is 2009 Court of Appeals case, lays out the distinction, as does the Ramirez case. There's a case that is, in fact, I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts. What I'm addressing is a slightly different point of law than that. Hold on, sir. 1 second. I'll give you two cases. One is Yntemav, Yntemav Smith, and that's 317 Georgia App 19, which was decided March 12th of this year, that covers the differences between the types of contempt. And there is another case I invite your attention to, and that is Silverstone, Syvertson, and that is 316 Georgia 865, and that was decided July 31st of last year. And Judge, I would just like to point out two things. The statute you were reciting about the supersedeas, it only says it's not mandatory. You still have the discretion to grant him a supersedeas bond. The other, I'm not going to grant a supersedeas bond. So you definitely have the discretion to grant him a supersedeas bond. The other issue is that if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies. No. Criminal is where you get to impose sentence, maximum of 20 days and a $1,000 fine. So if you're going to incarcerate him under criminal contempt, he's got to be sentenced. Well, his contempt is as long as when he tells me what the basis of the conversation was, I didn't ask him what, but he tells me that, then he purges himself of the contempt. Then that's civil. That's a civil contempt, Judge. That's civil. I would point you to regarding Hughes, which stands for the same point of law. Civil contempt imposed punishment as a means of coercing future compliance, yes, with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and a $1,000 fine. It is for all intents and purposes a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he is either going to jail or he is going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele has a zealous advocate for his client, and he is trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely he will be facing a bar complaint that could result in a suspension or loss of his license. So he is in a very, very difficult position where if he were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you are a witness, then everybody could present their side of the story. And I'm not going to do that. The reason is because that takes away the whole point of criminal contempt. That is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, or unethical. I just asked him to tell me, which is really kind of backwards. I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who, the person, because that Mr. Steele has indicated to us that he does not believe he can answer the question without also violating the privilege. Okay. And Judge, that's why we're trying to figure out if it's criminal versus civil. So if the issue is you are picking and choosing, you're saying, well, you get the bad side of criminal and no bond, but I'm trying to punish you civilly, which is when you hold someone until they comply. Okay, let me think about this a second. Okay, I'm going to take 5 minutes. I'm going to think about it. Thank you, Judge. Thank you. Okay, all right. We'll be in recess for about 5 minutes. Oh, this is killing me. The last bottle of water. Then I'm going to run to the store and get some lozenges for my throat. Oh, that's delicious. Good stuff. Court says, Sergeant Brown, is everybody present?
All parties are present, sir. Over.
Thank you for your patience, counsels. The court's had an opportunity to reflect. And Mr. Steele, if I could ask you to take the podium, please, and we'll stand next to your attorneys. Okay, Miss Merchant, Mr. Steele, and I apologize. Mr. Souser, Judge. One more time. Souser. Spell your last name for us. S-U-S-O-R. Sierra, Uniform, Sierra, Oscar, Romeo. You're a good man. Good man. All right. Thank you, sir. Mr. Souser as well. Counsels, I've made a clarification to the order of contempt. Mr. Steele, I'm going to still hold you in summary criminal contempt pursuant to OCGA 15133 for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated at the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Rice Street, Northwest Atlanta, Georgia, 30318 at 7 p.m. on Fridays, and you will be released 7 p.m. on Sundays. And it is to commence this Friday, June 14th at 7 p.m. and not to end until Sunday, August 18th, 2024 at 7 p.m., subject to further order of this court. And that will be entered and e-filed, and you may take whatever steps you and your counsel deem appropriate after that, okay? Can I ask you a question? Sure. I'm going to file a notice of appeal, but for whatever reason that doesn't take and you don't give a bond, then I ask that I can be with Mr. Williams and we work on our case all weekend for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time. That's up to, sir. If that comes to pass, you have my support. I will talk with our sheriff, and we may be able to make that work, okay, if that should occur. Okay, all right, counsels, I'm done with this, unless you have anything else. All right, thank you. Mr. Merchant, Mr. Souser? Thank you. Thank you, Judge. All right. May we get a copy of that order? Yes. In fact, the clerk is going to file. It's going to be e-filed. It's going to be on the e-file system momentarily. You should be able to get a copy of it from there. Directly download it from there. And Judge, Ms. Merchant and I will file entries of appearance on behalf of Mr. Steele as well. Sure, that would be great. Thank you so much. All right, State, is there anything else that we need to, or any defendants, anything else we need to take up before tomorrow morning? Mr. Copeland's going to rejoin us tomorrow morning, so we'll continue with his testimony. Where is Miss Bumpus?
Your Honor, I have a matter.
1 second. Where is Miss Bumpus? She hasn't been released yet.
I'm not certain. Miss Hilton is attempting to determine her whereabouts.
If you could call her, Miss Hilton, thank you. All right, Mr. Shart, sir.
Your Honor, I have to prepare my cross-examination of Kenneth Copeland over the next few evenings, and I would ask once again for the court to release the transcript of what occurred earlier today so that I may prepare my cross-examination.
I'm not going to do that, sir. Not at this point in time and specifically, okay?
Well, Your Honor, respectfully, and if it's not released by the time that we cross-examine Mr. Copeland, our defense will be hindered.
Sir, that will be an issue you can certainly raise then and now, but I'll think about it. But at this point, I'm not inclined to release the transcript of the court's ex parte hearing because of the way it was disseminated. That is why I'm not inclined to do it.
And I would also, I understand the court's ruling, I would also ask for the release of any audio tapes regarding that hearing as well.
Well, the only audio tape I know of is maintained by Miss Weaver, who tapes her proceedings in order to prepare her transcript.
I don't always record them,
says the court reporter. I don't know. She may not have any, but we'll see.
Your Honor.
Oh, this is Mr. Matthews Sr. I forgot his voice. Your Honor, Carlton Matthews on behalf of Mr. Huey. We're making the same request, Your Honor, for that transcript. We believe it potentially could contain some Brady materials, Your Honor. Sure. Okay. All right. Unless there is anything else. Counsels?
Your Honor, I join that. I also believe I advise the court the reason that I also want it for confrontation, cross-examination is supposed admissions Mr. Copeland made about our case outside our presence. And based upon information and belief, the court handed Mr. Copeland allegedly the law on false swearing and perjury. And if that is true, I would like to also talk with him. And if he will talk with me about how that came about, and I would like to read the transcript. So I'm joining in, but it also goes to matters discussed about the case based on information and belief.
Madam?
Your Honor, there was no matter to which either counsel for either of the defense was a party. There was no matter to which either defendant in this case was party, and that was had or held outside this courtroom. So we would ask that the court deny what is being requested of the court because it is something that which neither defendant is entitled. Your Honor, the witness is on the witness stand, Your Honor. The witness is on the witness stand. The witness is testifying under RICO Act, which covers all the defendants. It's our understanding upon information and belief that particular witness has stated again on Friday that he was not going to testify. He was going to plead the fifth. And today it was a different scenario. And based upon that, Your Honor, we believe that we should be entitled to that under Brady because we believe it's potential Brady material.
All right, sir.
And it's covered under the RICO statute. He's testifying against all the defendants under RICO. So we all are part of this witness's testimony. Your Honor, I would additionally point out that the question Mr. Copeland asserted the Fifth Amendment privilege was, how old are you?
On Friday.
Yes.
I'm going to deny your motion at this time, Mr. Matthews.
Your Honor, I don't understand the state's argument that we are not a party. This gentleman has sworn in a witness against all of our clients, was sworn in as a witness against all our clients. He is sworn in as a witness specifically against Mr. Stillwell. Conversations with that gentleman were occurring apparently ex parte without our knowledge, without my client's presence. And I don't understand how the state with a straight face can possibly say that we're not party to matters concerning a witness sworn in at trial to testify against our clients. We are certainly a party, and we are denied the right to be present.
All right. Thank you, sir. I'm still going to deny it. Anything else?
We would ask for a copy of that transcript since it's germane to the contempt. So we'll be asking for that from the court reporter. I assume this is the court reporter since that is.
It's an ex parte matter, so you're not going to get it unless the appellate court wants to see it, if see it is accepted. But I'm not going to give it to you at this point in time.
Your Honor, I assume the Harvey rule applies to this motion?
Yes, sir. Thank you. All right. See you all in the morning. Okay, 9:30 for anticipated 10:30 start time. We're in recess. We have just a couple. We might get through this. Teresa says, can admin buffer RA and ask if he would like readers to help him through some of this? Do we want somebody who wants to help read? We have a link. Oh, Welsh Lady, are you back? How long have you been back? Oh my goodness. I see you in the green room. Hang on. And now I can hear you.
I've been here all the time. Can you hear me now?
I thought you disconnected.
I did, but then I thought, oh, did he want me to go and help him read the other one? And so I messaged Amber.
I just finished all the voices. I did all the
know,
voices.
and I wanted to be Ashley Merchant.
I had to do the high voices. My voice will be rude. I can't sing happy birthday tomorw because I did all the high voices.
You're really croaky, Lefou.
Oh man.
I'll help you read. I even private messaged you in the chat.
I see it.
Chatting.
I am focused. This is my view. Ready? See this? I'm looking. I have all these screens. This. There are 3 places where I can see your message, but I'm looking at that, and all I can see is the court document. That's it. So, oh man.
I said, do
Okay,
you
so
need any help?
I will say
finished me.
we made good time. We are all the way to notice of appeal. Oh wow. Amber's adding pages. I just sent you 4 additional pages that just dropped regarding the order from Judge Krauss buffer. Okay, stop. Let me.
Well done, Amber.
We're going to pick this one up first because it's hot off the press. Give me just 1 second. We'll send this to Mac Studio. Oop. It's down here. Downloads. It's going to be this one. Pop it up full screen. Okay, we're gonna read this one first. Oh, that's Amber. This one's terrible. View. Continue to scroll. Okay, it's faint. Like their toner cartridge was running low. This is the judge that was handling the recusal motion. Okay.
Yes. Krauss.
Look at this title.
Krauss.
Judge Krauss. Order denying motion to recuse Judge Krauss from hearing recusal motion. So this is not the order. This is not saying we're not going to recuse Judge Granville. This is an order saying we're not going to recuse Judge Krauss from hearing the recusal motion. All
right. Will you?
Do you want to give it a go?
To help you, yeah.
Yes.
I'm on it too. You know. So
is it dark enough to read? Are you able to see that?
I can read it. I can see it. Yeah, I've got it on. That's fine.
I think we've got a few pages here, and you can skip all the case law stuff.
Okay, that's not a problem. Okay, just let me know when you want to chime in. Okay, so order denying motion to recuse Judge Krauss from hearing recusal motion. This case was randomly assigned to this court to consider certain motions to recuse Judge Glanville from further proceedings in this case. On July 8, 2024, defendant Jeffrey Williams filed a supplement to a motion to recuse Judge Glanville, Williams DKT 610. Though titled Supplement, a portion of the filing seeks to recuse this court from hearing the recusal's motions. Footnote 1. On July 9, 2024, defendant Williams filed an amended supplement to remove an assertion in footnote 2 of the original supplement. This court, therefore, must consider the portion of the supplement seeking the court's recusal before proceeding further. USCR 25.3.
This is just the law that they have to follow.
Do you want me to read it?
I was just saying this is just the law that they have to follow when they're told to recuse. What I like about this is Judge Krauss, as soon as he saw a motion to recuse him, he addressed it immediately.
I think it's a female.
She,
yeah.
Then I'm glad you're doing the voice. You can read the law if you want. You want to read it? You want to skip ahead?
I thought you did, Miss Merchant, quite well, actually, with that southern accent.
I'm not sure if she thinks I did well.
When a judge assigned to a case is presented with a recusal motion and an accompanying affidavit, the judge shall temporarily cease to act upon the merits of the matter and determine immediately 1. Whether the motion is timely, 2. Whether the affidavit is legally sufficient, and 3. Whether the affidavit set forth facts that, if proved, would warrant the assigned judge's recusal from the case. If all 3 criteria are met, another judge shall be assigned to hear the motion to recuse. Monday versus Magnolia Advanced Materials. Blah, 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 Home v. Shepherd, case law, assessing whether these criteria are met does not involve an exercise of discretion by the judge whose recusal is sought, but is a question of law to be determined by the assigned judge. See Mayor and Alderman, City of Savannah, Batson Cook, case law. Defendant Williams' motion in footnote 2 and later at a lengthy paragraph 52 asserts 2 bases for recusal of this court. Defendant Williams asserts that recusal is merited because of a $2,000 donation made by Judge Glanville to this court's recent re-election campaign. Defendant Williams also asserts that recusal is required because, quote, it is inappropriate for any judge to preside in any action where one of the parties holds a judicial office in any other court which sits in the same circuit, close quote. Defendant Williams' supplement seeking to recuse this court is supported by an affidavit, albeit only footnote 1 and paragraph 63 as to this court, and it was filed within 5 days of this court being assigned to handle the case. Therefore, the first 2 criteria are satisfied, and the only consideration for the court is whether the Judge Glanville's campaign donation to this court's re-election campaign warrants recusal. The Georgia Supreme Court has held that the mere fact of a campaign contribution to a judge, even from a party to the case, does not warrant recusal, where the contribution was not exceptionally large. Good v. State, or see also Woodham v. Atlanta, affirming denial of recusal motion based in part on a campaign contribution from...
Are you saying I have a job to do on this?
Yeah. From one of the judge's colleagues on the court who would recuse from the case, post v. State. Allegations of an exceptional campaign contributions or commonplace support during a judge's election campaign ordinarily are insufficient to require referring in a recusal motion for reassignment to another judge. The Code of Judicial Conduct reiterates this point, noting that when a campaign contribution is less than the maximum allowable contribution permitted by law, an affidavit seeking recusal must allege additional facts demonstrating the need for recusal. See Georgia re. CJC Rule 2.11. Quote, in summary, Rule 2.11 provides that 1. If contributions made to a judicial candidate or to that candidate's campaign committee are permitted by the law and do not exceed the maximum allowable contribution, then there is no mandatory requirement that the judge recuse. Got a footnote 2 there, I think. So
let me
I
scroll
don't know
down to
whether,
the footnote.
yeah. Oh, it's a website to tell you how
link
much
to campaign contributions.
Yeah. And so
can I stop
yeah.
this for just a little bit? This is getting heavy into where the law and politics meet, because believe it or not, judges in the US, they're nominated to the bench and then they're retained through an election. So they every 4 years go up for re-election, and you vote when you go to vote for whoever your local and national candidates are. You get the opportunity to vote on the judges in your area. And you say, should this judge be retained? Yes or no. Retained means they get to keep their job. No means we want them out. I think it's judges, like dirty diapers, should be changed often, and probably for the same reason. But
it's a nice analogy.
I always my law professor didn't like this very much because because he was a judge, and I told him that I think we should always change our judges, keep them rotating through. But they do occasionally get voted out. It's sort of rare for that to happen. Usually for them to be voted out, it takes a lot. In that it is an election, even though it's not partisan. I know this is getting a little into politics here. Partisan means you have to say, I am a candidate for this party. I'm on the ABC party, or I'm on the XYZ party. Whichever side you're on, you have that badge under your name. You say, I'm a ABC candidate or an XYZ candidate. And in a judge's case, it's nonpartisan. So there's no party affiliation tied to the position, but they still are running for election. So they'll still put out signs. They can put out signs, vote to retain, best judge yet, whatever. There's still those campaign costs. And so these donations, the Georgia law is just saying that if just the fact that you made a donation to somebody doesn't mean that you're suddenly now, impartial, and you can't hear that. So we're going to skip through a little bit of this. It looks like this is most of the ruling, and it's a lot of case law.
Yeah. We prefer pickles.
Yes. Let's see. There's this last part right here we want to pick up. If we start right here, the third.
Okay. Defendant Williams' additional assertion of Judicial Qualification Commission Opinion 220 in support of his motion is unavailing for two important reasons. First, Judge Glanville is neither a party nor counsel in this criminal prosecution, nor is this a mandamus action, and defendant Williams cannot make it so by filing a recusal motion. So, Opinion 220's conclusion that a judge should not preside in an action where one of the parties holds judicial office in the same circuit does not apply to this circumstance. Second, and perhaps most importantly, Defendant Williams' motion ignores the clear directive of Uniform Superior Court Rule 25.4. That rule directs that in a multi-judge circuit, like the Atlanta Judicial Circuit, a recusal motion shall be assigned for hearing to another judge, and the selection shall be made by use of the circuit's existing random impartial case assignment method.
So random draw. That's how Judge Krauss was chosen.
This court does not relish the task to which it has been assigned, but it is as much the duty of a judge not to grant the motion to recuse when the motion is legally insufficient as it is to recuse when the motion is meritorious. Jones v. A. Minor Group. See also Hampton Island Founders versus Liberty Capital. For the foregoing reasons, the portion of Defendant Williams' supplement and amended supplement seeking to recuse this court is hereby denied.
So Judge Krauss is going to stay on and hear the motion to recuse. She's going to go
shall. It says shall, so she has to, isn't she?
Shall. Yep, it's right there.
She's picked from the draw.
Let's see. Yeah, we're in the right place. Look at this. I'm not sure if you can see the slider on the right-hand side. Do you see this little slider button right over here?
Just when you move it, yeah.
It's, well, I shouldn't move it very far. We are over 3/4 of the way. We're not quite 80%, but we're over 3/4 of the way through.
I'm
Which
here all
means-
night, love.
we have to be done. We have to be done by 7 o'clock because we have another live stream starting with.
Oh, well, yeah, of course.
Yeah.
Yeah, of course. I have nothing planned, so
Okay.
I'm all right.
Some of these might go a little bit faster. So let's see. This is the notice of appeal. I'll read this one. This is the notice of appeal given that Brian Steele hereby appeals to the Court of Appeals of Georgia for the order of contempt. He's appealing his contempt order, holding Brian Steele in criminal contempt. The clerk will kindly take note that the transcript of evidence of the proceedings on June 10th are to be included with the record on appeal. No other portion of the record is to be included for this appeal. The Court of Appeals of Georgia has jurisdiction of this case on appeal this 10th day of June. All business. There was his appeal. A certificate of service. That means that it's been provided to the right person. Next, we have another motion for Mr. Steele. This is a motion for supersedis bond on criminal contempt. He wants a bond. Okay, he wants to be basically let out of jail until his case can move forward, and then he can be sentenced. Now comes the movant in the above stated action and moves this court for a supersedis order, as the grounds therefore states the following. The movant, this is Mr. Steele, was adjudged in contempt of court by an oral order of this court issued today. The court has declined to issue a written order. Movant has filed a timely notice of appeal. A copy of said notice is attached hereto and incorporated as part of herein as Exhibit A. Unless a supersedis is granted, the questions to be raised by appeal in this case will become moot, and movant will be denied the right of appeal, and that unless supersedis is granted, irreparable injury will result to movant from the instantaneous enforcement of the sentence of the court. This court must grant a supersedis bond under OCGA 5613. There is no discretion under the statute. Wherefore, it is requested that the court issue an order of supersedis bond. Submitted on June 10th. So that was something that he literally filed as he was walking into the jail.
His wife is doing it. So she was on the ball.
Yeah, and the judge noticed. I mean, in the documents in the transcript, he's literally it popped up on his screen. Oh, guess who just filed these motions? These just came in. They were fresh, very fresh. This last one I'll read as well. This is a notice of appeal. Notice is given that Brian Steele hereby appeals to the Court of Appeals of Georgia from the order of contempt on June 10th, 2024, holding Brian Steele in criminal contempt. The clerk will kindly take notice that the transcript of evidence of the proceedings on June 10th are to be included in the record of appeal. No other portion of the record is to be included for this appeal, and the Court of Appeals of Georgia has jurisdiction on this case of appeal. This 12th day of June, signed Attorney Steele. And there's a certificate of service with everyone's email if you need to reach anybody. Another certificate of service, meaning that was delivered. And this is a fun one.
Oh, okay.
You ready for this one? Do you want to read this one?
Yeah. Me? Okay. Let's go. Comes now, Brian Steele. I love Attorney Steele. Movant herein and hereby files this motion to set aside contempt in the above referenced case, and so we should too. In support of this motion, movant shows as follows. Movant is counsel of record for Jeffrey Williams in indictment number 22SC 183572 in Fulton County Superior Court. The jury trial commenced on January 4th, 2023 and is ongoing. Today, on June 10th, 2024, the court, along with the state prosecutors, engaged in an ex parte hearing with a sworn witness from whom an order of immunity was issued. The witness had previously asserted his Fifth Amendment privilege and was held in contempt. The court and the state admitted on televised court proceedings that this meeting took place. Attorney for defendant Jeffrey Williams, Brian Steele, commenced proceedings in open court on June 10th, 2024 by disclosing that the defence had knowledge of this information, demanded same, and proceeded to make motion for mistrial. The trial court immediately inquired of Mr. Steele how he came into possession of the information and expressed outrage that Mr. Steele knew of this information. Citing State of Georgia Bar Rule 1.6, confidentiality of information, Mr. Steele declined to provide that information. Rule 1.6, in pertinent part, states as follows. A lawyer shall maintain in confidence all information gained in the professional relationship with a client, including information which the client has requested to be held inviolate, or the disclosure of which would be embarrassing or would likely be detrimental to the client, unless the client gives informed consent, except for disclosures that are impliedly authorized in order to carry out the representation, or are required by these rules or other laws or by order of the court. Comment 5 to this Rule 0.16 specifically states the principle of confidentiality is given effect in two related bodies of law, the attorney-client privilege, which includes the work product doctrine in law of evidence, and rule of confidentiality established in professional ethics. The attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. The rule of client-lawyer confidentiality applies in situations other than those where evidence is sought from the lawyers through compulsion of law. Rule 1.6 applies not merely to matters communicated in confidence by the client, but to all information gained in the professional relationship, whatever its source. A lawyer may not disclose such information except as authorized or required by Georgia Rules of Professional Conduct or other law. See also scope. The requirement of maintaining confidentiality of information gained in the professional relationship applies to government lawyers who may disagree with the client's policy goals. The court repeatedly demanded that Mr. Steele reveal the source of this information, claiming that the way Mr. Steele obtained that information was unlawful. Mr. Steele relied on Rule 1.6 and declined to provide the source of information, which was never alleged to be deemed confidential by any court order, placed under seal, or subject to a protective order. The court held Mr. Steele in criminal contempt for refusal to provide information and ordered that he be taken into custody. The court temporarily permitted Mr. Steele to participate in trial for the day, but has indicated that at the close of business it will again address the matter and demand that Mr. Steele reveal from where the information was obtained. Based upon information and belief, Mr. Steele will decline to disclose this information. Hours after holding Mr. Steele in criminal contempt, the court stated that Mr. Steele can only purge himself of contempt by telling the court from where he had got the information that he shouldn't have had. Thus, the court has imposed an illegal and inherently inconsistent punishment for this criminal contempt. Moreover, the court has involved himself in these proceedings, and thus the court must recuse and allow these proceedings to be handled by a separate court. Where the announcement of punishment is delayed and where the contumacious conduct was directed towards the judge, or where the judge reacted to the contumacious conduct in such manner as to become involved in the controversy, the judge may give the attorney notice of specific charges. But the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. The court has stated that this is criminal contempt, but has not afforded Mr. Steele due process, including a right to notice and to be heard. The court has refused to issue a written order of contempt, stating that this is a criminal contempt matter. Mr. Steele's statements have not interfered with or posed an imminent threat of interfering with the administration of justice. An attorney may be held in contempt for statements made during courtroom proceedings only after the court has found, 1, that the attorney's statements and the attendant conduct conduct either actually interfered with or posed an imminent threat of interfering with the administration of justice. And 2, that the attorney knew or should have known that the statements and attendant conduct exceeded the outermost bounds of permissible advocacy. Because contempt is a crime, the evidence must, of course, support these findings beyond a reasonable doubt. See Jefferson, Burton. To the extent that this it's okay. To the extent that this court believes contempt is civil, there must be a clear and unequivocal order of the court that Mrs. Steele is deemed to violate that needs to be addressed and remedied. It certainly cannot be law that every time a judge asks a question, the failure to answer lands you in jail, especially when counsel has colorable, sorry, there's no you in there, colorable basis for declining to answer the question. Wherefore, movement requests that this court reconsider and rescind the order of contempt. Alternatively, this court should immediately grant Mr. Steele a supersedeas bond this 10th day of June 2024. Signed by Attorney Steele.
Wow.
His wife.
And then we get a certificate of service there as well. Colette Steele. So this certificate, State of Georgia, I hereby certify the foregoing transcript was taken down. This means the court recorded. There's Christina Weaver again. So we have another transcript. Oh, that was for the previous transcript we were at, I think. And then, man, we're not quite done. This was on 6/17. Motion to disqualify and recuse Judge Glanville from all further dealings in the above referenced case, and motion for mistrial, which was goaded by improper conduct committed in concert by the court and prosecution. Goaded. This is funny. I always love when they have words like that written in the title, because the proper way to respond to this is to reference the full title, which makes them have to say these same words like goaded in their response. They say motion for mistrial, which was goaded by the improper conduct. They have to say that in their response.
They have to repeat it all, yes.
And it's like getting somebody to say that they committed a crime. It just, you hear the words coming out of their mouth, and it's a legal gotcha. It doesn't actually change anything. It's just how it's done, but I think it's funny, and
it's always repeated there as well in the first paragraph after the comes now. Yep. It's then
you get it twice, double dose.
Yeah.
So this is from Jeffrey Williams, counsel. This is from Jeffrey Williams, who's the client, and he's going through the counsel. So the counsel is filing this for him. And this is a motion to disqualify and recuse Judge Glanville from all further dealings in the above referenced case, and a motion for mistrial, which was goaded by the improper conduct committed by in concert with the court and prosecution. In support of this motion, Mr. Williams shows as follows. And some of this is going to repeat a little bit. Undersigned counsel represents Mr. Jeffrey Williams in the above styled referenced case. The jury trial of multiple accused persons commenced January 4th before Fulton County Superior Court Judge Glanville. The trial is expected to last at least through the end of the 2024 calendar year. On Monday, June 10th, within 5 days of the filing of this timely motion, this court, along with its prosecutors, engaged in a unlawful, improper ex parte meeting along with other persons, a sworn witness, Kenneth Copeland, for whom an order of use immunity had been issued on Friday, June 7th. No notice of this ex parte meeting was provided to any attorney for any of the criminally accused in this case. In fact, the accused and their counsel were in the dark that the Star Chamber meeting occurred. Mr. Copeland had previously been called to testify on Friday, June 7th, asserted the Fifth Amendment privilege in open court in front of the jury, and was held in contempt and summarily incarcerated until such time as he agreed to testify pursuant to the grant of use immunity. Judge Glanville and the prosecutors essentially admitted by silence and by statements in open court that an ex parte meeting occurred on the morning of June 10th, 2024, only after undersigned counsel revealed, based upon information and belief, that this impermissible meeting occurred. At the earliest opportunity on the afternoon of June 10th, the court was informed, based upon information and belief, that the ex parte meeting with the sworn witness, Kenneth Copeland, and the prosecution occurred earlier that day, that the witness had made factual admissions and that statements were made to the witness by the court and the prosecutors acting in concert about the amount of time Copeland would be held in custody on the contempt. This court denied undersigned's counsel's request for a transcript of the ex parte meeting and denied the timely motion for mistrial based upon the improper and illegal ex parte meeting, which violated Mr. Williams' constitutional statutory rights, including the right to due process, fair trial, fair tribunal, ethical prosecutors, and the right to be present at every critical stage of the proceedings under the Georgia Constitution. The footnote says that a transcript of the relevant proceedings has been ordered from the court reporter. A video recording the entire thing can be accessed on YouTube, where things live forever in infamy. Uniform Superior Court Rule 4.1 and Georgia Code of Concert Judicial Conduct 2.9 delineate rules governing ex parte communications. Uniform Superior Court Rule 4.1 generally prohibits ex parte communications except as authorized by law or by rule. Judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Ex parte hearings are only authorized in the case of extraordinary matters, such as temporary restraining orders and temporary injunctions. Yeah. In other judicial hearings, both parties should be notified of the hearing with an opportunity of attending and voicing any objection that may be properly registered. And we've got case law here.
They weren't even notified. They weren't even told.
Not even after the fact.
No.
It's one thing to say, hey, we're going to have a meeting. You're not invited. It's secret. It's stuff that doesn't concern you. That's what they should have done before they met. After the fact, they should have said, hey, we had a meeting. It didn't concern you. They didn't. Instead, they covered it up and they acted all offended when things were blown out of proportion.
Oh, yes, that was shock. You weren't expecting to get found out, and he was. And,
It's crazy. This is actually law. We're not going to read this because we've been over this several times in many other filings. These parts have been quoted over and over. But this is the rule 2.9, assuring fair hearings and averting ex parte communications. It basically says don't do it. Don't do it unless you absolutely have to. And if you do, follow the rules. But yeah, don't do it. The court violated USCR 4.1 and Georgia Code of Judicial Conduct 2.9. The court has joined the prosecutor's team and is biased against Mr. Williams and favorable to the prosecutors as objectively demonstrated on June 10th, as well as throughout the pendency of this case. Trial court rejected undersigned's counsel substantive request for information about the unlawful ex parte meeting, and the court denied undersigned counsel's motion for mistrial. Instead, the court stunningly demanded to know how the undersigned counsel came into possession of the information about the ex parte meeting. The prosecutors stunningly sat mute and permitted this injustice to occur for the court and for the court to attempt to intimidate undersigned counsel. Later, Love, a lawyer currently employed with the Fulton County District Attorney's Office, the currently part is a jab. It's literally saying, you won't be there long.
Currently.
This is the level of how this fight is going back and forth.
Oh, they don't like it. Oh, there is no bones to pick.
No love lost.
No love lost.
Yes. In this case, love is lost.
No, for either, and it's made well known of as well. They've said in front of the judge. I don't know, listen to it, and she'd called them different things, and so yeah, there's this. No, currently employed is a bit of snark. I love a bit of snark, though.
It's good, and it's just tucked in there because it's accurate. It's factually accurate. She is currently employed, but why would you say that? Her latest job, it's hilarious. I'm just noticing that there's like a star supernovaing behind you on the wall.
This is my flames of my red dragon.
It looks beautiful.
Let me show you. Right.
It's mesmerizing.
See, here's my dragon.
There's the dragon. That is a Welsh dragon. Looks beautiful.
Yeah,
there's the flames.
So I have my red dragon flames.
I have a. Well, I say I have. I hope to get when property is just distributed from my parents when they pass away. Hopefully that doesn't happen anytime soon. But one of the items that I hope passes to me is a rock about this big that's engraved with a Welsh dragon on it.
Oh,
It's
wow.
a rock from Wales that's engraved with the dragon. It's the Welsh dragon.
Yeah, I know the dragon. This one.
So I've
Tried.
got my that's the one. So I'm hoping that finds its way my direction.
Talking
Okay,
of which, just to
yeah.
interrupt, I noticed somebody in chat asked me to say something that I know you asked me to say once, and I learned I learned how to say it properly. It's Llanfail Pwlgwyn Gilgoch Geriech Chwyndrofer Lantresilioch Go Go Go.
Bless you.
Thank you.
Was that town name again?
It is the longest town name in the world.
I feel bad for anyone who even has to send a letter there just to mail it. I mean, is there a shorter name you use, like an abbreviation?
No, I mean, a lot of people know it like when they say, oh, go, 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 then we know that they're on about the long place name. But yeah.
Well, I mean, like in London, when I was in London, you could basically put the postcode on something and it would get almost exactly to the place. The postcode is like a zip code. So like SW72PA, I could get in that area of London, right down to that exit where the tube comes out. Is there like a short code so you don't have to write out the town name on your envelope?
I'm sure there is a postal code for it. Yes, I'm sure there definitely is. But do you know what it means? It means St. Mary's Church in the hollow of the White Hazel near a rapid whirlpool, and the Church of St. Cecilio near the Red Cave. I just read that.
That was going to be my first guess.
What his interpretation was. Yeah, we don't do things by. There we are. Llanfail Pwlgwyn Gilgoch Geriech. Gilgoch Geriech Chwyndrofer Lantresilioch Go Go Go.
Go 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 go. That's as far as I can.
You got to kind of like.
Goch.
Yeah, when that horrible sound that you make when you doing a yeah.
Amber says, I'd hate to be a court reporter or scribe for anybody within that town. It's like, please put your court name on your address on the record for the courts. Anyway.
Yeah, Llanfail Pearl. Yeah. Llanfail Pearl.
It's amazing. The fact that you pronounce that is crazy.
Well, I learned it for you because you asked me once for it before.
I did. We've also had you say things like magically delicious.
I know. And greeners and absolutely. And yes, you've had me say lots of things.
And not my gumdrop buttons. Did you say not my gumdrop buttons?
No, but I can. Not my gumdrop buttons.
This is the line from, I forget what it is. It's the Gingerbread Man. In what's the movie? Not my gumdrop buttons.
Oh, is it Shrek?
Yes, it's from Shrek. Have you seen that part?
It's the only one. I know what a gingerbread man is involved. And I felt sorry for him to eat his leg or something. They bite his leg off.
During all this, we have Brooke, who became a member.
Let the dog out a moment.
Okay,
I'll
keep reading here.
Yeah, I'm still with you, just yabbering on with a bit of Welsh in between a court transcript.
We're gonna finish. All right, Brooke, welcome. Glad to have you as a member. We normally watch court. We normally don't read a whole lot of documents. This document dropped in our lap, and it's 233 pages long. This is stream part 2 of reading this. So let me see if we can continue this. We just had the insult that the prosecutor is currently employed at the Fulton County District Attorney's Office. So lawyer Love argued that the ex parte hearing with witness Copeland was ethical, just, and proper. The other prosecutor still remained mute. Undersigned counsel declined to join the antics in ignoring rules and ethical provisions and declined to provide information requested by the court, relying on the State Bar Rule of Professional Conduct 1.6, which states that a lawyer shall maintain in confidence all information gained in the professional relationship with the client. And we're going to skip that because we've read this so many times. And then comment 5 to Rule 1.6. This was cited previously in the other filing. The bold part that's pertinent says the attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. The rule of client-lawyer confidentiality applies in situations other than those where evidence is sought from a lawyer through compulsion of law. Rule 1.6 applies not merely to matters communicated in confidence by the client, that would be the attorney-client privilege, but also all information gained in the professional relationship, whatever its source. So if you represent a client, doesn't matter where the information came from, you have to keep it confidential. A lawyer may not disclose such information except as authorized or required by the Georgia Rules of Professional Conduct or other law. The court ignored the ethical rules relied upon and continued to demand undersigned counsel to reveal the source of the information, claiming that the way the undersigned counsel obtained that information was somehow unlawful, and baselessly accused the undersigned counsel on the record of potentially acquiring the information through eavesdropping. In response to the specious. Hey Siri, define specious.
Specious means superficially plausible, but actually wrong.
Oh, there you go. So thank you. I got the pronunciation from Welsh Lady and then the meaning from Siri. In response to the specious accusations and the impermissible demands of the court, undersigned counsel relied on the ethical mandates of Rule 1.6 and the Fifth Amendment right to remain silent and declined to provide the source of information which had been proffered. It's funny because he never cited the Fifth Amendment. He cited Rule 1.6. So I'm not sure if he can say that he relied on that other than, in his own head. He never said I plead the Fifth, because pleading the Fifth would indicate that there was something illegal that happened that I don't want to testify against, right?
Yeah, I don't
remember him saying anything about pleading the Fifth.
Amendment to remain silent. Inclined to provide the source. No, he didn't say I plead the Fifth.
Yeah.
But he said that he would not tell him, and he said, I will not tell you.
Yeah. So the court is so biased against undersigned counsel and or Mr. Williams, and court ignored all laws and pursued contempt penalties to attempt to intimidate undersigned counsel to violate the law and ethics in order to continue to help the prosecution convict Mr. Williams and all others. The court issued a written order of contempt and incarceration for Brian Steele, imposing the maximum sentence of incarceration for 20 days. The Supreme Court of Georgia has granted a writ of certiorari. You knew how to say this at one point. Certiorari. I like the way you said it. To address the appeal of the contempt order and has granted undersigned counsel a superseded bond. This is important. The Supreme Court stepped in already.
Yes.
Those appeals that Mr. Steele filed that we read previously, they took action immediately. Boom. He never spent a weekend in jail. And they also granted him the bond that the judge said, I'm not going to order that. I'm not going to grant you the bond. They did. So it doesn't make those contempt charges disappear. I think that's through a separate document.
Yeah.
Has the judge taken care of those yet? I think he did drop it.
He hasn't. I don't think he hasn't done anything with it. It's still open. The contempt for attorney still. Yeah, but they did give him a supersedious bond. They all unanimously agreed.
Okay. So good. The court violated the law by failing its duty to recuse from presiding over this contempt proceeding. In such proceedings where the announcement of punishment is delayed and where contumacious, did I say that right?
Contumacious, yes.
Nailed it first try.
Well done, Ray.
Was directed toward the judge, or where the judge reacted to the contumacious conduct in such manner as to become involved in the controversy. The judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. Here, the court involved itself in these proceedings by joining the prosecution team and conducting the ex parte meeting that violated Mr. Williams' rights. This created a conflict of interest for the court because its own unethical conduct is questioned and at the heart of this issue. The court then compounded its abuse of power by presiding over the very contempt hearing where its own rules violations prompted the controversy. The court should have recused and allowed the contempt proceedings to be handled by a separate court. Further, the prosecutors sat mute and permitted the court to attempt to interrogate and intimidate another member of the bar who reported a violation of law and also promoted the court's wrongful conduct by asserting that the ex parte meeting was proper. Mm-hmm. The court denied Mr. Williams and undersigned counsel their due process rights, as undersigned counsel has a right to adequate notice to be heard, to call witnesses at a hearing, to be represented by counsel for the entirety of the contempt proceeding, and Mr. Williams had the right to learn of all the facts and circumstances of this critical stage of the proceeding that occurred in his absence ex parte.
Yes.
The court abused its authority by holding undersigned counsel in contempt for refusing to divulge privileged information and for protecting Mr. Williams' constitutional rights to due process, right to a fair tribunal, right to a fair trial, right to be present, and effective assistance of counsel. This court's refusal to acknowledge these rights and protections has created an unfair tribunal based upon bias against Mr. Williams and or his counsel and favoritism to the prosecutors. So the motion to disqualify and recuse Judge Glanville is timely filed, as Uniform Superior Court Rule 2.51 mandates that the time for the filing shall not be later than 5 days after the affiant first learned of the grounds for disqualifications. The Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed if it's filed within 5 days after the affiant learned of the grounds, excluding Saturdays and Sundays. So they say timely, it's good. Thus, this motion to disqualify is timely filed by the reason of this disqualification. Recusal was first learned on Monday, June 10th. The record also reveals numerous instances during trial when the judge's behavior appears to have been biased against Mr. Williams' counsel, impartial in favor of the state. See Mailhouse v. State. I'm going to skip this case law. The record reveals other instances too when the trial court wrongly berated counsel in front of the jury.
Yeah.
After a number of such incidents, Mr. Williams' counsel, out of the jury's presence, moved for the trial judge's recusal and sought a mistrial on grounds that the judge had shown a lack of objectivity, had displayed bias against Mr. Williams and his counsel, and had assisted the prosecutors in making their case before the jury. Judges have an ethical duty to disqualify themselves from any matter in which they have a personal bias or prejudice concerning a party or an attorney appearing before them. In this regard, a trial judge shall avoid all impropriety and appearance of impropriety. The Code of Judicial Conduct provides that judges should disqualify themselves in a proceeding in which their impartiality might reasonably be questioned, including but not limited to instances where the judge has a personal bias or prejudice concerning a party or party's lawyer. Within the context of this requirement, the word should means shall. The Supreme Court is mindful of the extraordinary pressures attending a criminal trial of this magnitude. On the one hand, defense counsel is obligated to vigorously defend his client against all charges brought by the state. Likewise, prosecutors must effectively and ethically present the state's case to a jury. At the same time, the trial judge is charged with ensuring that the rules of evidence and procedure are followed and that the proceedings are both orderly, ethical, and fair. When these several interests come together in the courtroom during trial, disagreements between the bench and bar are to be expected. These instances discussed above and in the attached Exhibit B, joint affidavit, however, represent more than mere friction between zealous counsel and a diligent jurist. This seems really like we've read this one before.
Yeah.
Is this a duplicate?
No, it's not a duplicate, but it's containing some of the same language.
I think they copied and pasted parts of this.
I think it's because we also know that that's what was going on. We've seen it.
Yeah. The judge's conduct, as discussed above and herein, created the impression that he harbored an inclination to be biased against Mr. Williams and his counsel and partial towards the prosecution. Higher courts need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he has a personal bias or prejudice concerning a party or a party's lawyer. As explained, the trial judge in this case participated in ex parte communications with the prosecutor in which he assisted the state to influence a witness to testify against Mr. Williams. These actions certainly raised reasonable questions concerning the judge's partiality and bias. Because the trial judge's impartiality is reasonably questionable, it is error to deny Mr. Williams' motion for recusal. Our highest court has set forth at least 3 circumstances in which recusal of court is necessary on the ground of mere appearance of bias. Even in the absence of actual bias, Mr. Williams does not waive the actual bias has been objectively shown throughout trial, as well as on June 10th. But for simplicity, the appearance of bias is also met. 2 of these circumstances arise in the case at bar. The third circumstance is which recusal is required on the ground of mere appearance of bias, absent evidence of actual bias, is when the judge has a direct personal, substantial, pecuniary financial interest in reaching a conclusion against a litigant based upon information and belief. This, where's the footnote? Continue. This circumstance is not applicable to the case at bar. So they're saying the judge doesn't have like a financial outcome. He's not going to benefit financially one way or another from this. First, mere appearance of the bias requires the recusal of a judge when the judge becomes embroiled in a controversy with one of the litigants. In Maybury versus Pennsylvania, we see that also in Taylor v. Hughes. As shown in Exhibit B, attached here too, the court favors the prosecution and is attempting to sabotage the defense. Georgia courts have followed this demand for recusal when the judge becomes embroiled in a controversy. In Berger, it's case law says due process requires that the trial judge cannot be both the prosecutor as well as the judge in our judicial system, thus must be recused. Also in Adams, where the judge did the same, the judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted in front of an unbiased, impartial judge. So both case laws show that there should be a different judge that hears this. Schoolcraft also, the trial judge applied his impressions from a prior bond hearing and reaching a finding of potential contempt. Second, due process. What's that?
Do you want me to take over, or are you okay?
I think I can do a little bit more, but
okay, go on.
Get ready.
All right, okay.
Second, due process requires recusal of the judge when the judge takes a role in the accusatory process, as shown in Murchison. Our highest court explained that the Constitution prohibits a scenario where the judge orders witnesses to appear before him in order for the judge to gather facts to determine whether contempt proceedings should occur when the same judge presides over this contempt trial. This is because such a judge grand jury arrangement caused the judge to become part of the accusatory process, and thus this judge must be recused from further dealings on the case. That's the first time we've seen this argument made.
That's new. Yeah, I was going to say that's new.
So the judge ordering someone to appear so he can do an investigation under threat of contempt to see if there should be contempt charges. It is a judge grand jury situation. Here, a Judge Glanville has ordered Mr. Copeland's lawyer and others to appear to give information on a contempt proceeding, same as against the law. That's Miss Bumpus that they're referring to. Importantly, a trial judge has the duty to recuse itself sua sponte from any proceeding with which the judge's impartiality might reasonably be questioned, including instances where the judge has a personal bias or prejudice concerning a party. The phrase impartiality might reasonably be questioned means the existence of an objectively reasonable perception of lack of impartiality by the judge, held by a fair-minded and impartial person, based upon objective fact or reasonable inference. To warrant recusal, the alleged bias must be of such nature and intensity to prevent the complaining party from obtaining a trial uninfluenced by the judge's prejudgment. To warrant disqualification of the trial judge, the affiant in support of a motion seeking the same must support the charge of a bent of mind that may prevent or impede the impartiality of the judge. Do you want to read 22? Mr. Williams meets this mark.
I don't know, because can I be with my dog? Because if you can, I got to go and get him in. He's only in my bedroom.
I can hear him.
So he's going to pick up on this chat, see? So on your chat, on the
maybe
stream.
He's reading as well.
Okay. I'm going to go and get him. Okay. And then he'll shut up then. I'll be back. Give me 2 seconds.
Yep. Do you want me to put you in timeout? Oh, there you go. Okay. Recusal is objectively required when the judge serves both as the accuser and the adjudicator in a case. In the case at bar, we are so done. We are so close to being done, guys. We're going to finish this on time. In the case at bar, the court met ex parte with prosecutors and sworn witness Copeland and never intended to reveal that the ex parte meeting occurred to Mr. Williams and or his counsel, or to anyone for that matter. The court has become part of the executive branch prosecuting Mr. Williams. Moreover, the prosecutors have abandoned and violated their ethical duties by engaging in this ex parte meeting and sitting silent while the court held undersigned counsel in contempt and failed to reveal any Brady evidence from the meeting, including the fact that this meeting occurred. The court and the prosecutors should not be working together, but they are, teaming up to gain an unlawful advantage over Mr. Williams. Mr. Williams' trial is constitutionally fractured, unfair, and lacks all constitutional, statutory, and ethical safeguards and protections of due process and of law. The court is biased against the accused and his counsel. No intellectually honest person could believe that coercing witness Copeland to testify in a star chamber setting meets constitutional muster. This court has failed to follow the lawful path. Instead, the court has unlawfully become the prosecutor, judge, grand jury, biased, partial, potential senator, and thus must be removed from this case in toto, instanter. On a motion to disqualify and recuse, it is the duty of the judge to pass on only the legal sufficiency of the facts alleged, to ask whether these facts support a charge of bias or prejudice. Neither the truth of the allegations nor the good faith of the pleader may be questioned, regardless of the judge's personal knowledge of the controversy. The test is whether, assuming the truth of the facts alleged in the affidavit, a reasonable person would conclude that bias exists on the part of the judge. Welcome back. I think you're muted. Now you're back.
Thank you. Is that perfect timing or what?
Sounds great. Sounds great.
That's what I said.
Do you have a pup with you?
Yeah, he's by he's calling.
He's
My little
he's
Italian
hidden.
grey. He'll go cut down. Right. Okay. 26. Yeah.
Yes.
This court's conduct raises a strong finding that it has become personally embroiled in this case. It is clear, even to the casual observer, that this court's involvement in this controversy requires this court be disqualified, recused, removed from all further proceedings in the above referenced case instanta, and another judge who will duly exercise the powers of the judicial branch with partiality, clarity, and fairness must be appointed to this case. See Dowdy v. Palmer. It is critical to the functioning of our courts that the public believe in the absolute integrity and impartiality of its judges and judicial recusal services as a linchpin for the underlying proposition that the court will be fair and impartial. See Mayor and Alderman of the City of Savannah via Batts and Cook. The Georgia Code of Judicial Conduct, Rule 2.11, A, mandates that a judge must disqualify himself in any proceedings in which the judge's impartiality must be reasonably questioned, or which the judge has a personal bias or prejudice concerning a party or a party's lawyer. This motion is to disqualify, recuse Judge Glanville, accompanied by the attached affidavit, mandates that Judge Glanville, one, shall immediately cease to act upon any matters involved in State of Georgia versus Jeffrey Williams et al. Supra, shall immediately determine the timeliness of this motion and legal sufficiency of the attached affidavit, and assuming that any or all facts alleged in the affidavit to be true, whether recusal would be warranted. If it is found that this motion was timely filed, which it is, the affidavit is legally sufficient, which it is, and that recusal would be authorized if some or all of the facts set forth in the affidavit are true, which it does, Judge Glanville must cease from any further contact with this case, and another judge shall be assigned to hear this motion to disqualify, recuse Judge Glanville. Judge Glanville cannot in any way oppose this motion. See Mondi versus Magnolia Advanced Material. The attached joint affidavit clearly set forth the facts and reasons for the belief that bias and/or prejudice exist on the part of Judge Glanville. The allegations in the attached affidavit are not just bare conclusions and opinions, but are facts. See Mundy v. Magnolia. Georgia Code of Judicial Conduct, Rule 2.11, mandates that Judge Glanville must disqualify, recuse himself from the case instanta. In the alternative, another judge must be assigned to this case and then order Judge Glanville recused based upon his conduct as stated herein and in the attached affidavit. The facts cannot be ignored. To wit, Judge Glanville's impartiality might reasonably be questioned by an objective observer, and thus Judge Glanville must be disqualified, recused from this case. See Britt v. State. A fair-minded and impartial person would hold a reasonable perception that Judge Glanville lacks impartiality based on the objective facts set forth in this motion and attached affidavit, or reasonable inferences therefrom. See Ellicott versus State. Reasonable perception of a lack of impartiality held by a fair-minded and impartial person is based upon objective facts or reasonable inferences. Furthermore, Judge Glanville's potential bias is of such a nature and intensity to prevent Judge Glanville from being uninfluenced by his prejudgments. Judge Glanville's conduct gives fair support to a charge of a bent of mind. Hang on, let me just read that again. Judge Glanville's conduct gives fair support to a charge of a bent of mind that may prevent or impede the impartiality of the justice if Judge Glanville is not disqualified, recused from this case. See Johnson v. State, Kappelmeyer v. PDQ. Further,
you still good? Do you want me to take
now
one
he's
over?
coming out to see. Further, this indictment must be dismissed. I know where he wants to go. So, under the blanket. Idiot. Further, this indictment must be dismissed. A mistrial cannot granted based upon the court's and prosecution's continued misconduct, as shown as in Exhibit B attached here to a constitutionally required fair trial occurring before a fair tribunal with ethical prosecutors has been violated. This includes, but is not limited to, witness intimidation. See, for example, United States versus McCloskey. United States, Linda, Morrison, Golden.
Lots of citations. All right, we're almost done. We're to the almost to the wherefore.
Judge Glanville, lawyers for the state Love and Hilton will be called as witnesses at trial for the jury to understand this ex parte meeting and determine demeanor and credibility. Additionally, Mr. Williams demands all ex parte meetings to be disclosed instanter in order to properly reveal the full extent of all violations of law or ethics. See, they think it's happened before, and whether it happened with Bean and
this might be the tip of the iceberg.
Again, lawyers for the state Love and Hilton and Judge Glanville are necessary witnesses at this hearing and trial to determine the correctness of the motion for mistrial goaded by conduct of the parties and judge. Wherefore, based upon the above and attached affidavit, if Judge Glanville does not immediately recuse from any and all further dealings on this case, this motion must be set down before another judge to determine why Judge Glanville can continue to serve as a judge in this case. Further, a mistrial must be granted based upon these judicial and prosecution violations of law and ethics, the 17th day of June 2024, from Brian Steele and Keith Adams.
So we have a few more pages of stuff here. This is the order of contempt and incarceration for Brian Steele. This, I believe, comes from the judge.
I was going to say, I think that's from the judge, isn't it?
Yeah. During the proceedings in the above-styled case on the afternoon of June 10th, one of the two representatives for defendant Jeffrey Williams, Mr. Brian Steele, took to the podium and stated to the court that he had been informed of an ex parte communication which took place in the court's chambers that morning. This is the judge putting down in writing the whole order, why he's going to be held incarcerated. This is committing it to writing, which he has to do. The only parties present for this ex parte matter were the court's official reporter, representatives from the state's witness, Mr. Kenneth Copeland, and counsel for Mr. Copeland. In addition to the court's serious concern with how this information was improperly disclosed to defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. The court having told Mr. Steele multiple times that he needs to tell the court how he came into that information, and the court having explicitly warned Mr. Steele that he faces contempt of court should he not comply, the court finds Mr. Steele has repeatedly refused to follow the court's order. Every court has the power to compel obedience to its orders and to control the conduct of persons connected with a judicial proceeding. One who obeys an order or command of the court may be found in criminal contempt. Before a person may be held in contempt for violating a court order, the order should inform him in definite terms as to the duties thereby imposed upon him, and the command must therefore be express rather than implied. The question of whether a contempt has occurred is for the trial court. Its determination will be overturned only if there has been gross abuse of discretion. Once an act has been determined to constitute contempt of court, the action of the court takes to deal with the contempt determines whether the contempt is deemed criminal contempt or civil contempt. The distinction between criminal and civil contempt is that criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority and to punish disobedience of its orders. Case law says that direct summary criminal contempt which arises in the presence of the court and tends to scandalize it and hinder or obstruct the orderly process of the administration of justice, the preservation of order and decorum in the court, is exempt from the due process requirements and of notice and hearing. The judge is saying, I did it right. Shouldn't have been a hearing, no notice, not needed. And they've got Moody v. State. Accordingly, it is hereby ordered that pursuant to court's authority under OCGA 15133, the court holds Mr. Steele in direct criminal contempt for failure to comply with the court's order. It is further ordered that Mr. Steele shall be taken into custody of the Fulton County Sheriff and incarcerated at the Fulton County Jail for no more than 20 days for this contempt, with those 20 days consisting of every weekend for the next 10 weekends. Mr. Steele is to report to the Fulton County Jail and will be 7 p.m. on Fridays and will be released at 7 p.m. on Sundays. Mr. Steele's incarceration is to start this Friday, June 14th at 7 p.m. and is not to end until Sunday, August 18th at 7 p.m. subject to further order of the court, signed by Judge Glanville. Now we have, see how long this is a long one. I'm not sure if we
paragraph at a time. Come on, Ari, we got this. We got this down now, right? Everybody's
come so far.
We've come so far. Well,
my brain
you got
is
your
exhausted.
time in though for Canton. No, Canton, is it?
Canton,
it is Canton.
Canton Select Board.
It is
yeah.
Canton. Yeah. Oh, I've only just realised that's a place where my grandparents live.
Really?
We're
They
not
live there?
Massachusetts.
Are they townies?
Yeah.
Are they on the select board?
No, it's not in Massachusetts anyway.
Let's see. Today, coming airtime.
Spin my chair to the left. Oh, no, I'm not in my wheelchair. I'm on my sofa. But I'll move my butt for you. My bottom. I do apologise. Sorry, forgot what channel I was on. Mind you.
We've talked all
you
about
and Siri today.
Yeah. I have no words. I can't say anything today. All right. Joint affidavit of Brian Steele and Keith Adams, Esquire. We are over the age of 18 and suffer no legal disability. We make this joint affidavit based on our own personal knowledge. We're counsel for Jeffrey DeWilliams in the above styled case. On Monday, June 10th, and thereafter, affiants learned of the following events, and the fact occurred outside of Mr. Williams' presence and outside of affiant's presence and in a star chamber-like environment.
On Monday, June 10, 2024, undersigned affiants, specifically Brian Steele, asked to have a transcript of whatever conversations were memorialized, and affiants requested the actual recording of anything discussed at this improper in-chambers meeting on said date. This court has obstructed Mr. Williams and below affiants from having an exact image of what was said. This obstruction alone shows that the court, everybody wants to see you. I know, but can you look our way, Col? Is this Colin? Everybody, so Mr. Williams and below evidence from having an exact image of what was said. The obstruction alone shows that this court is biased, as there is absolutely no privilege in communication in the court's chambers, as this court argued on June 10, 24. And there is certainly no attorney-client privilege under any stretch of the imagination, as this court asserted. The obstructionist conduct by this court shows bias, and this court is intrinsically intertwined in the facts of this case and has prevented Mr. Williams from due process, fair trial, effective assistance of counsel, right to know every material and critical happenings in his case. Further, this court, by its words used on the records when speaking in open court with affiants, as well as the court's silence, as well as lawyer Love's statements in open court, clearly demonstrates that the facts below are true and accurate. The court was also silenced witnesses by improperly issuing a show cause order for contempt, and thus making all witnesses in fear of going to jail if the truth is told about this improper violation that Mr. Williams' constitutional right to be present at every critical stage of his trial, fair tribunal, effective assistance of counsel, due process under the law, the right to make a record in this case. The court is biased and must be recused. Further, the cross-examination of Mr. Copeland will include facts that occurred at this Star Chamber meeting, which puts the credibility of lawyers Love, lawyer Hilton, this court in issue, and this court should never be the person who is in charge of the jury when the court's conduct is being questioned based upon the court and lawyers for the state of Georgia's actions. Mr. Williams has been put into a trick box by the misconduct of lawyer Love, lawyer Hilton, and this court. This court must be recused, mistrial declare, barred by double jeopardy, based upon the prosecutorial misconduct and judicial misconduct. Mr. Kenneth Copeland, a witness who have been called by the state and sworn on Friday, June 7, 2024, and who invoked his Fifth Amendment, was held in civil contempt by this court, was brought to Fulton County Courthouse on Monday morning, June 10, 2024. Unbeknownst to affiants, Mr. Williams, or anyone else on the defence side of this case, the court met in its chambers with Mr. Copeland, his counsel, lawyer Love, and also lawyer Hilton, and at times court reporter Weaver, as well as sheriff deputies and other persons. Deputies may have been instructed to turn off their body cameras.
There was and is nothing privileged under law about this improper ex parte meeting. The court and others met with Mr. Copeland for a lengthy period of time. The total ex parte meeting lasted more than 1 hour and approximately 2 hours, with the above-named people at the meeting at all or various times. Mr. Copeland continued to make known his assertion that he would not testify even in the face of being held in contempt and ordered to testify under use immunity. This court and the lawyer for the Fulton County District Attorney's Office, Love and/or Hilton, ignored Mr. Copeland's decision and continued to declare to Mr. Copeland that he would be held in custody until he testifies, or alternatively, if he persists in refusing to testify, he would be held in custody until not only Mr. Williams' current trial resolves, but until all 26 indicted persons' cases are resolved, whichever is longer. This court was a participant and was present during these admonitions and threats to Mr. Copeland. This is a witness intimidation, coercion, and the court has become a member of the prosecution team in assisting the prosecution to induce a material witness to testify. This court, lawyers Hilton and Love are now all witnesses in this case and will be called by Mr. Williams and or possibly other accused so the jury can determine demeanor and credibility of what occurred at this in-chamber meeting. Please note that the witness list is hereby amended by this joint affidavit to include the court, lawyers Love and Hilton, and all other relevant material persons that have information to share with the jury regarding the conduct, words, and actions at this ex parte communication. This court provided Mr. Copeland with a written copy of the statutes on crimes of perjury as well as false swearing. This is no subtle gesture, and one that helped the prosecution team to obtain their mission for Copeland to change his mind and testify. Lawyer Love made representations to this court in front of Mr. Copeland and his counsel, sheriff's deputies, the court reporter, and others that Jonathan Melnick, Esquire, counsel for Mr. Copeland, committed misconduct during his representation of Mr. Copeland and was not representing the interest of Mr. Copeland. These are knowing misrepresentations by Lawyer Love to this court, which Lawyer Love continues to do, which biases this court in favor of the state and against the accused. Their lawyers and other members of the bar further, their lawyers and other members of the bar. Further, the court permitting Lawyer Love to speak ill of Mr. Copeland's counsel in front of Mr. Copeland adds to the coercion and witness intimidation. This ex parte discussion violated Mr. Williams' constitutional right to, pursuant to Article 1, Section 1, Paragraph 12 of the Georgia Constitution, to be present at every material stage of this trial. The court and Lawyer Love and or Hilton speaking with Mr. Copeland, a sworn witness, about his testimony, whether he would change his mind and testify, is clearly a critical stage of the proceedings. Example, Scudder v. State.
It is.
He asserted in her motion, as asserted in her motion to recuse this court, filed on June 14th, Attorney Bumpus, by her counsel, verified the below facts. These facts are adopted into the affiant's affidavit as below. These facts are assertions of Attorney Bumpus as statements of her lawyers. See Parrish v. State, as follows. On Monday, June 10th, at approximately 8:30 a.m., Mr. Copeland and his lawyer, Attorney Caleb Bumpus, were escorted to the court's chambers and conducted an ex parte meeting regarding whether Mr. Copeland would testify. Those present for the substantive portion of this meeting were Judge Glanville, Mr. Copeland, Attorney Bumpus, lawyers Love and Hilton, members of the court's security staff, and deputies, 2 investigators from the Fulton County District Attorney's Office, and the court reporter. In chambers, this court asked Mr. Copeland whether he was prepared to testify. Mr. Copeland announced that he planned to again invoke his Fifth Amendment privilege on the stand. A conversation among the parties ensued regarding Mr. Copeland's understanding of immunity, how Mr. Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Mr. Copeland learned that he could be held indefinitely by the court if he refused to testify, not just 2 years as he initially believed, Mr. Copeland decided that he would testify. Mr. Copeland added that his testimony would be a lie. The meeting ended and the parties went to the courtroom.
Right. The court never assured that this Brady evidence would be revealed to Mr. Williams or his counsel, and Brady evidence includes the fact that this meeting occurred. Instead, this court takes the position that no information about this meeting should have been revealed to Mr. Williams, his counsel, or anyone outside of the Star Chamber where same occurred. This shows that the court has become a member of the prosecution team in an effort to thwart Mr. Williams's constitutional right to a fair trial and a fair tribunal and due process, and right to be present for each critical stage of the proceedings. Right to call witnesses, right to present a defense, right to cross-examine witnesses on critical topics, including the facts of this case were discussed including the facts of this case were discussed with the court during the intimidation of the witness. This court must be recused. The court and prosecution have violated Mr. Williams's rights, and the indictment must be dismissed after a mistrial is declared, as the court and the state has goaded Mr. Williams into moving for this mistrial recusal of the court. On Monday afternoon, June 10, 2024, at approximately 1 p.m., once affiants made the above known in open court refused to release the transcript of this improper ex parte occurrence, held Mr. Williams's lawyer in contempt of court, ordered Mr. Williams's lawyer to serve the maximum period of time in custody for contempt, all in an attempt to intimidate Mr. Williams and his counsel from understanding and learning about the court's and the prosecution's wrongdoing. The court has become a material witness because undersigned counsel has the right for the jury to understand that this court met with Mr. Copeland and the prosecutors in order to convince Mr. Copeland to testify against Mr. Williams. The improper ex parte meeting on June 10, 2024, with a sworn witness concerning the witness's willingness or non-willingness to testify, and this court giving the witness a copy of the law of perjury and false statements and discussing facts of the case is unforgivable. This is not an ex parte meeting that the court has had with the affiants ever. On the very few occasions that affiants have had an ex parte hearing with this court, affiants announced in open court that it needed to speak with the court ex parte. There was no objection by the prosecution, and same occurred. Never was a witness involved in the rare ex parte meetings. Affiant's demand to question this court and the above lawyers for the District Attorney's Office as to how many ex parte hearings they have had, the substance of those meetings, who was present, and the like. Even if just one ex parte meeting occurred, as did on June 10, 2024, this mandates that the court has forfeited his role as an impartial judge and has become a member of the prosecution team. The court must recuse itself. The court, on at least on one occasion, has been fed improper ex parte information about the facts of this case and a witness's statement about his refusal to testify. The court met with the witness and spoke with the witness about the witness's willingness or non-willingness to testify along with the prosecutors, and then held undersigned counsel in contempt when undersigned counsel simply wanted to know why he was not notified of this ex parte judicially and ethically prohibited meeting.
The court. Oh, sorry. Go ahead.
Go.
The court has now placed the lawyer for Mr. Copeland and other unknown persons in a position that they need to come before the court on a certain date to give testimony as to who gave information to affiants concerning this improper June 10th Star Chamber meeting with Mr. Copeland, the prosecutors, and the court. The court has become the executive branch conducting an investigation as a grand juror prosecutor. This court has lost all impartiality, and Mr. Williams cannot receive a fair trial with this court being present over the proceedings. This court has falsely and wrongly accused affiant, specifically Brian Steele, of being unprofessional and unprepared in front of the jury. Neither claim was close to the truth or was accurate. The prosecutor sat silent as affiant was wrongly and falsely accused of improper conduct. This court has violated every neutrality, impartiality that was sworn to undertake. See Johnson v. State. Even knowing that the court has falsely accused Brian Steele of being unprofessional and unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper comments. This clearly shows this court is biased and impartial against Mr. Williams and or his counsel in favor of the state, as no fair judge would not correct such a serious misstatement made in front of the jury. The bias of the court is objectively proven. When Mr. Copeland took the witness stand on Friday, he refused to testify and was taken into custody by this court. This court knew, as did the prosecution, that Mr. Copeland would refuse to testify in front of the jury, but the court did not reveal that fact or take any action to stop Mr. Copeland's refusal to testify in front of the jury. Mr. Copeland's refusal to testify in front of the jury prejudiced Mr. Williams a great deal, and the jury should never have heard Mr. Copeland exercise his Fifth Amendment right.
Correct.
This court told the courtroom deputies to prohibit the media from filming Mr. Copeland if or when the court ordered him to be arrested. They warned Court TV this was going to happen before it happened, meaning they knew it was coming.
Cameras
this direction,
and the photographer, they said, don't film if we got to put cuffs on him.
Yeah. The direction occurred before Mr. Copeland even took the witness stand on Friday, June 7th. The court has harmed Mr. Williams by hiding this information from Mr. Williams, having ex parte communications with the deputy and media, permitting Mr. Copeland to assert his Fifth Amendment right in front of the jury. When the Honorable David Botts, Esquire, brought to the court's attention that he had the evidence the prosecution knew that Mr. Copeland was going to invoke his Fifth Amendment right in front of the jury, this court refused to have a hearing to determine whether the prosecution knew that this witness would invoke his right to remain silent or refuse to testify. And instead, the court had a problem with Attorney Botts. This is backwards. This court has shown bias against Mr. Williams, his lawyers, and in favor of the prosecution. This court must be removed from further dealings on this case. This trial must be mistried based on the goading and improper conduct by the court and the prosecution, and another trial is prohibited and barred by double jeopardy.
In sum, the court must be recused and or the trial be declared mistried based upon the improper judicial and prosecutorial conduct that includes, but not limited to, the court, lawyers in Love and or Hilton are now witnesses because they helped Mr. Copeland change his mind and testify by coercion. The court, ex parte, assisted the prosecution team by convincing Mr. Copeland to change his mind and to testify against Mr. Williams. The court has obstructed justice by ordering any transcript of the June 10th, ex parte meeting not to be produced to affiants to use to particularize this affidavit, as well to cross-examine Mr. Copeland, the court, the lawyers for the state, and all others before the jury. Facts of the case were discussed with the court at this impermissible ex parte meeting, and Brady evidence was not revealed to affiants by the court and or lawyers for the state. And Mr. Williams has questions for Mr. Copeland, this court, lawyers for the state, and others about this improper ex parte meeting, how same occurred, who discussed the fact that this secret meeting would occur, and the substance of this meeting, so the jury can decide whether the court and the state have colluded against Mr. Williams. I swear that the above is true and accurate. Further afference says not Brian Steele.
I like the further affiant.
Keith
It's just so formal. It's so formal. Not saying anything more on this. That's where we leave it. And then we have the certification for the fact that it was delivered. We're getting down to the end. We have some exhibits here, and I think we're getting to the emails. Exhibit E is for email, right?
Ooh.
Let's see. Order of contempt and incarceration.
You might have a content warning because there's an F word in there.
Another one?
There might be in this email. I'm just.
Oh yes.
It might be.
There will be if because before we got the F word from. We got the F word, and then we got a recounting of the F word. So this would be F word number 3 for this reading.
Okay.
This is the order of contempt and incarceration for Brian Steele.
I'll do my own beeping.
Okay.
Okay.
Do you have a beeper?
Beep.
Oh wow, you do. I would play my beeper for you, but it's ear-splittingly loud. Okay, I'll do a short one. Your dog might hear it. Is that too loud?
Yeah, that's fine.
Okay, I've got a beep.
Yeah, you got to hold it down a bit longer if it's a bigger word. Yeah.
Okay.
Yeah.
During the proceedings in the above styled case, this is the order of contempt and incarceration for Brian Steele. During the proceedings of the above styled case on the afternoon of June 10th, one of the 2 representatives for defendant Jeffrey Williams, Mr. Brian Steele, took to the podium and stated to the court that he had been informed of an ex parte communication which took place in the court's chambers that morning. The only parties present for this ex parte matter were the court's official reporter, representatives from the state's witness, Mr. Kenneth Copeland, a counsel for Mr. Copeland, in addition to the court's serious concern with how this information was improperly disclosed to defense counsel. Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. The court having told Mr. Steele multiple times that he needs to tell the court how he came into that information, and the court having explicitly warned Mr. Steele that he faces contempt of court should he not comply, the court finds Mr. Steele has repeatedly refused to follow the court's order. Every court has the power to compel, according to the law. I think we read this already. It's like a duplicate entry. One who disobeys an order of command of the court may be found in criminal contempt. Violating the court order, the order should inform him of the definite terms as to the duties thereby imposed upon him, and the command must therefore be expressed rather than implied. We have the law right here. We have some case law as well. Accordingly, it's hereby ordered that pursuant to court's authority under the law, the court holds Mr. Steele in direct criminal contempt for failure to comply with the court's order. It's further ordered that Mr. Steele should be taken into custody on the Fulton County Sheriff and incarcerated at the Fulton County Jail for no more than 20 days for this contempt, with those 20 days consisting of every weekend for the next 10 weekends. Mr. Steele is to report to the Fulton County Jail.
Give him the max.
7 p.m. on Friday, released on 7 p.m. on Sundays. Mr. Steele's incarceration is set to start Friday, June 14th, and should not end until August 18th at 7 p.m., subject to further order of the court, so ordered this 10th day of June by Judge Glanville.
And Steele says, all right, chuck me in with my client.
Yeah.
I love it.
That's cool. We've got a lot of stuff to go over anyway. As long as we get bunked together, we'll be good.
Oh, okay.
Now this is what? This is in the Superior Court of Fulton County, State of Georgia versus Jeffrey. Indictment. Order compelling witness testimony pursuant to OCGA. Do you want to start this one? We are so close to the bottom.
Okay. The State of Georgia, so order pursuant to OCGA. 245507. The state of Georgia, having moved this court pursuant to OCGA 245507 to compel the testimony of witness Kenneth Copeland and District Attorney Fanny T. Willis. I wasn't expecting Fanny Willis to be, sorry, Phony Willis. Should I speak called Phony?
How does she say it?
She says it's phony.
Okay.
But it's Fanny. You got, but you know.
She got her own name wrong.
Yeah.
Happened.
Yeah. Okay. Well, but I wasn't expecting to see her there. District Attorney Phony T. Willis, having determined that the testimony of Kenneth Copeland is necessary to the public interest. Footnote 1. Quick.
Oh, sorry, that's my job. Scrolling down.
Go. Providing that whenever in the judgment of Attorney General or any District Attorney, the testimony of any person or the production of evidence of any kind by any person in any criminal proceedings before a court or grand jury is necessary to the public interest, the Attorney General or the District Attorney may request in writing the Superior Court to order such person to testify or produce the evidence. Okay, back up now. Yeah.
There we go.
Okay. Kenneth Copeland has been properly subpoenaed to appear before this court to testify. Footnote 2. Go down.
Scrolling. See Exhibit A.
Personal surveys. Oh, gosh, man. And to the state of Georgia, having provided to this court sufficient reason in support of its motion to compel the testimony of Kenneth Copeland. Footnote 3. The attached ex parte motion of the to compel testimony pursuant to CGA 245507.
Okay.
This court finds that Kenneth Copeland has been properly subpoenaed to appear before this court to testify in the trial of the instant case, and that the testimony of said Kenneth Copeland is necessary to the public interest. Accordingly, it is hereby ordered that witness Kenneth Copeland shall appear before this court beginning Friday the 7th of June 2024 at 9 a.m. and provide testimony in the trial of the above styled case and shall continue to appear and testify until released by this Honourable Court. Further pursuant to OCGA 24.5.5078 said Kenneth Copeland shall not be excused on the basis of privilege against self-incrimination from testifying or producing any evidence required. However, no testimony given by Kenneth Copeland as required under this order, or any information directly or indirectly derived from the testimony of Kenneth Copeland given by Kenneth Copeland as required under this order. Didn't I just say all of that? But I repeated myself.
Seems a little redundant.
Yeah, shall be used against said Kenneth Copeland in any proceeding or prosecution of a crime or offence concerning which he testifies under this order. Kenneth Copeland shall be subject to prosecution or to penalty of forfeiture for any perjury, false swearing, or contempt committed in testifying or underlined failing to testify in accordance with this order. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court of this state, the United States, or any other state. Finally, it is ordered that should said Kenneth Copeland refuse to testify after this order is entered, said Kenneth Copeland shall be subject to being adjudged in contempt of court and shall be subject to commitment by the court of the Fulton County Jail until such time as said witness purges himself of contempt by testifying as ordered to do so by this court and this order. This order shall be entered of record in the minutes of this court, and any testimony given by Kenneth Copeland pursuant to this order shall be transcribed and filed for permanent record in the office of Fulton County Clerk of Superior Court, so ordered this 7th day of June 2024. Oh, prepared by Adrian Love.
Yay, go Adrian Love. She prepared this for the judge.
Prepared it for the judge.
Now, and that's actually pretty normal, though. The judge will often tell an attorney, hey, prepare an order for me, write it up, and I'll sign it. So but it just does. It's funny that they are working together. All right. This is a short one. The above styled case is currently before the court. This is order of recusal on defendant DeMonte Kendricks, June 12th, motion to recuse Chief Judge Glanville, non-party Caleb Bumpus, June 14th, motion to quash, order to show cause, and motion to recuse the court, and defendant Jeffrey Williams, motion to disqualify or recuse Judge Glanville from all further dealings in the above referenced case, and 2, motion for mistrial, which was goaded by the improper conduct committed by the concert. This is the part I'm telling you about. They have to put this title, and they have to put the goaded by the improper conduct in there. The judge has to write this. I'm responding to the motion for improper conduct in concert by the court and prosecution, collectively the motions. Upon review and reconsideration, because the first time he denied them all, right? So this is all reconsideration of the recusal motions. It is hereby ordered and directed that these recusal motions to be heard by another judge pursuant to Uniform Superior Court Rule 25.1. The court clerk is hereby directed to reassign the recusal motions to another judge pursuant to Uniform Superior Court Rule 24.1. Et seque, I don't know what that Latin is, and the court's local rules. So ordered the first day of July. He finally gave in. The court notes that this order is in contravention of the court's June 14th order on motion to recuse Chief Judge Glanville. Accordingly, the June 14th order is hereby rescinded. The court further notes that it has canceled the July 3rd show cause hearing for Ms. Bumpus. Thus, her motion to quash order to show cause has been rendered moot. Regarding Mr. Williams' motion for mistrial, which was goaded by the improper conduct committed by the concert by the court and the prosecution, the court defers ruling until such time as the recusal motions have been ruled upon by another judge.
Ooh, that sounds ominous.
Yes.
I'll wait till what the other judges do first, and then maybe I'll have a little bit of feedback on this.
All right. If you want to read this one, I'm finalizing the thumbnail for the live stream, which starts in less than an hour.
Okay. Order requiring written response to recusal motions. This case is before the court to consider motion to recuse Judge Uriel Glanville from further handling of the above captioned case. 2 defendants and counsel for a witness. Specifically, the motions before the court are defendant DeMonte Kendrick's motion to recuse Chief Judge Uriel Glanville, filed on June 12, 2024. Defendant, it's docket. I wondered what that was. Kendrick docket 247. Defendant Jeffrey Williams motion to disqualify, recuse Judge Glanville from all further dealings in the above referenced case, filed June 17, 2024. Williams docket 587. Non-party Caleb Bumpus and motion. Caleb Bumpus's and motion to recuse this court, filed June 14, 2024. Adams docket 171. Time is of the essence, given that a jury trial is currently paused pending resolution of these recusal motions. Therefore, the court hereby orders the state to file a written response to the pending recusal motions on or before 5 p.m. Monday, July 8, 2024, contemporaneously with filing. The state shall provide a courtesy copy of any filings by email to the court's litigation manager at that email address. It is ordered the 2nd day of July 2024 by the Honourable Rachel Krauss,
who is going to handle all this. Now, look, we are almost done. Almost done. I thought there was emails on here. Exhibit I. Yes, we're to the emails. We made it to the emails. They're at the very bottom. Okay, this is Max Shart. To Kenneth Copeland, to a Courtney Edwards, the Steele law firm. Lots of email. We can go through who got this and where. I think it's funny that Attorney Melnick uses a Yahoo email address, And the
still
steel law firm has
around.
an MSN. I have an old Yahoo email
An
address.
MSN.
So it's just
And
it's
my
funny.
space as well.
It's hilarious. So he says, I've been Mr. Copeland's attorney. He tells me that he repeatedly told you that when you were questioning him, I also spoke with Don Geary extensively about Mr. Copeland when he was assigned to this case. And I spoke with Miss Love early in the process around the time jury selection was beginning. I have a plea with a judge, Carnicel, tomorrow at 9, and I will come to the courtroom as soon as I'm done. John, I think we have to go to the bottom.
Yeah. Is it
backwards.
one of those ones where you go all the way to the bottom? Let's have a look at the dates.
This is 1 of 2. This is 2 of 2. So right here, we start at the bottom. This is from Jonathan Melnick to Adrian Love, Hilton,
Simone
Steele
Hilton.
the law firm Sharp. So Max Sharp, Attorney Steele, and the 2 prosecutors from Jonathan Melnick, who was Mr. Copeland's attorney. Good afternoon, all. It's come to my attention the Fulton County District Attorney's Office has questioned my client, Kenneth Copeland, without my knowledge or consent. Please be advised that my client does not wish to speak with any member of the Fulton County District Attorney's Office, nor any law enforcement officer from this point forward. My client will assert his privilege under 5th Amendment tomorrow and will not testify. Look at the date, June 6th. They knew.
Yes.
They knew.
Yes, they knew
And here's the email
Thursday.
proof.
And he had been telling them. Woody had been telling them before we...
Let's see. Good afternoon. I hope all's well. In our conversations with Mr. Copeland, he advised that you were not his attorney and had not spoken with you. However, if you're asserting that you are his attorney, we will cease communication, but your client is under subpoena and is expected to be here at 8:30 a.m. It is our understanding your client does not have the transportation, so we're planning to pick him up with lights and sirens and shiny brass bracelets.
How nice.
So please make sure that he is present so we don't have to take any further action if he fails to appear for his subpoena. Thank you and have a great evening. And then the reply was, I've been Mr. Copeland's attorney. He tells me he repeatedly told you that when you were questioning him. I also spoke with Don Geary. He was about Mr. Copeland when he was assigned to this case, and I spoke with Miss Love early in the process around the time jury selection was beginning. I have the plea with Judge Carnsdale, so he'll be there tomorrow. So this is the proof that the attorney said, hey, we know that there's going to be he's going to plead guilty. Certificate of service. And look at this. Yes, we hit the bottom.
We did it. Yay. We did it, Ari. The dogs come out to play.
We just got through 233 pages. I didn't read every word. I would not have made that without you, Welsh Lady Reads. Thank you so much.
You're more than welcome. I would have been there sooner. I was just sat in the back room.
You're in the green room. You could hear me, and I couldn't.
I thought,
see you at all.
Olivia, I could do you're struggling with your voice, and you were doing the females, so I was a bit like, oh, bless, But no, I've had fun. And chat. I've seen a little comments here and there, and I just want to say thank you. You're so kind. All of you been so lovely. See, I'd have been Miss Merchant for your luck. No problem.
I'm scrolling up to the top again. I'm still scrolling. Hang on. Okay, there we go. All the way up to the top. Let's go ahead and remove that. We don't need this anymore. There we go. Welsh Lady Reads. Let's see. Dog Lover says, from now on, let me get to the bottom. I'll use the right. Holy cow, there's a lot of comments here to read. Whoa.
She won't accept any papers. Dog Lover. I am sorry. I'm not for everybody. I do understand that.
That's funny. That's really funny. Welsh Lady Read, I think you did an absolutely amazing job. Once again, if you're not subscribed to Welsh Lady Reads, you should be on YouTube. She's a great individual, fun to have around, great accent. It just makes me smile to hear you talk, even when you read court papers.
Yeah. So getting your mouth around those tongue twisters.
Yeah, I'm going to sleep with like ice just around my jaw tonight, I think.
Yeah.
Do that.
Well, anytime you want a reading partner, you just let me know, and I'll happily come and read any document with you. Sorry, I'm trying to make sure Colin doesn't show his butt to everybody, because that's not very. I said it again. Bottom to everybody.
Is Colin a whippet or part
He's
greyhound?
an Iggy. He is a proper Iggy. Aren't you? Look.
He's a runner.
Everybody wants to. I know.
So you take him
My
out to the
boy.
park, and he just goes full stride.
Yeah, but
It's like a bullet.
He's got to be literally kept an eye on, because he'll just go. The towns they go there if they see something. See this scratching he does?
Yeah.
He's scratching and pouring. That's because he just wants me to do that.
He wants under the blankets.
And then I sit here then with the dog in between my legs.
He looks happy. Well, Sweetie, thank you.
You're more than welcome. Thank you, everybody. Thank you for your lovely comments, and for people who came over as well to my channel. Thank you. Thank you so much. Scott, you're amazing as always.
Thank you.
Please thumbs up, everybody, for the recovery addict. Now, mind, he has worked so hard this afternoon.
I'm a little tired. That's all. All right.
This time I'm going for real, all right?
Okay. I won't leave you in the green room. Thanks a lot, Welsh Lady Reads.
No, it was my fault. I came back in because I was like, "Do you need help, people?"
Thank you. Have a great evening. We'll see you.
Take it. No star, everyone. No star.
Bye. What a great person. What just a great person. She's awesome. All right. Here's what we have going. I'm just finalizing a let's see, let's upload this one. I'm finalizing my picture for the thumbnail for the Canton board meeting. I sort of need to crop it a little bit. I'm trying to we'll see if it works. We'll see. I've got this idea for how I want the meeting to look. Let's make this the backdrop by trimming it down a bit. Okay. Layer. There we go. Almost. There we go. Ooh, nope, a little bit more. Send to back. We'll just take this little ceiling fan, which I think should be appropriate. We're going to insert that right up there. Perfecto. Okay. We have our thumbnail. And let me download that. Compress the file. We're going to go live at 7 o'clock, which means we have a whole 40 minutes before the Canton Select Board meets. We're probably not going to stay on for the entire Select Board meeting, but there is a period of 15 minutes where the Canton Select Board opens the microphone for karaoke. No, just kidding. It would be funny if it was karaoke, but it's just open microphones where residents get to say whatever's on their mind. They only allow 15 minutes of the entire meeting. That's all they allow. And they sit there and just time people, and they're like, all right, done. And that's it. And they don't respond. They don't do anything else. And the people are livid. Okay, they're so frustrated. They're like, you can hear me, but you're not listening. You're not doing anything about it. And they're just frustrated. And it's become a way for those that mostly are not townies in the town to just vent on what happens. And it's also become sort of an outlet for members of the town, the community, to express their opinions about the Karen Read trial and about the police, about the whole process. Everyone involved in it. And you never know where it's going to go. This is just an open forum. We've had people there who have been wearing free Karen Read shirts. They've been holding signs. It's been interesting. So RA monopolizes the open comment portion by reading court transcripts. Okay, here we go. We're gonna get this ready. So let me first build a new stream for Canton. It's gonna be this one. Or use settings. Too many E's in meeting. Only 2, I think. Call this live Canton Select Board meeting, July 9th. Even though on their website they say Tuesday, July 8th. It's actually tonight. 2024. Everything's selected correctly. We're going to go live here in about a few minutes, in 20 minutes, I think 22 minutes or 18 minutes maybe. And we need a new thumbnail. Change to, did I not download this? Where'd it go? I think it's in downloads. There it is. And it's live. It's up. So first in chat is going to get to indicate that by just typing in chat here just a minute on that next live stream. But where we are now is we're going to rest my voice just briefly. Oh, guess who was first in chat? 3 people were in there before I even could load on my own computer, and I'm the one who made it. Greeners, congratulations, Greeners. Let's see. Let me make sure it doesn't switch. Yep, it was Greeners. Okay. That being said, I will redirect. This time I will make the portal. I'm doing that right now, so I don't forget. Customization, redirect to Canton Select Board, save. And that one's good. Okay, so the redirect is made. Let's see. Would you pull up the rest thumbnail, go to page 4 and see if either of those names work? Yeah, let me do that really quickly. Rest portal is on camera 3. See page 4 for suggestions. Let me scroll down just briefly. This is a community document right here. There we go. Let's scroll down. I found it helped to add text boxes on this page that explains what elements are added and why. Or I can keep better track of the thumbnail as it evolves from Red. Thank you, Red Pen. Alec Edition, not a producer. The Ballad of Harland Rust, Baldwin's character in the movie. We've got some suggested items that might make an appearance. I like the glasses for sure. Copy paste, edit a title. Which title looks good? Rust Movie Trial 2, Rust Movie Trial starring Alec Baldwin. Rust Movie Trial, Alec Edition. Red loves this one. I like this one as well. Rust Movie Trial starring Alec Baldwin. That is great. I think that's a clear winner. Rust, let's go. Red, let's go with that one. I'm not going to put it to a vote. Executive decision. Oh, now Red loves the ballot. Now you love the one on top, says Steve. Steve loves that one. Okay, so all right, Steve, I see you moving. Red loves this one. Red, do you love Rust Movie Trial 2? Is there too much? Are there chats on screen? Hang on 1 second. Oh, I'm sorry. Let me take that off. I was looking at a different screen. And let me turn this off too. Is that better? Can you see that a little better? Red loves the top one. I like them all. I like the starring Alec Baldwin because it's more like a movie credit. And he's an actor. I like that second one. Although Rust Movie Trial 2 is also, they all pay homage. Well, at least the top 2. I like that they pay homage to the film industry in their title. Okay, Red says I like the starring one. We're going to go with that one. Second one it is. Good call. Good call. All right. We're going to wrap up briefly and have a break before we begin again. This is all the water I have left. It's all the water in the house. Deer Park, it's about time you sponsor. It's about time you sponsor Deer Park because we need some more water. Whoa! Judge dismissed charges against George Allen Kelly. Was it with prejudice? Was it with prejudice? That's what we need to see. With prejudice or without? Was that new today? Well, I mean, the charges were going to be dismissed, but one way or another. With prejudice. It's done. Wow, that is amazing. Welsh Lady Reads, thank you so much for your help today. It was wonderful. I would not have gotten through it on my own. That is amazing. That is great news. Add Alec Baldwin to the first one. We might amend it later on. All right. I know you guys have been with us a long time today. We have one more thing left to do, and that is the Canton Select Board meeting. We are going to be joining that when it starts at 7 o'clock. Before then, at about 6:45, in about 15 minutes, we're going to go live and get everyone ready. So bring your popcorn, get everyone's seats arranged for the public comment period, which is always a hoot. So yes, we're going to go sit in the city council meeting in Canton, Massachusetts, and it's going to be a blast. So thank you very much. We'll try to answer some questions when we start again. My brain's just fried. I just to get up and walk around, breathe some fresh air, find something to drink, maybe eat another salad, and then we'll be back. 15 minutes. 15 minutes. That's all we give you. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in about 15 minutes with the Canton Select Board meeting. Have a good one, guys. We'll see you. That's the wrong one.